mention the for listing lordship. Kindly 3rd March. Related to financial.
Not 3rd March. Not on 3rd.
Item
9.
May please, Your Lordship. My lord, in respect of item number 12, my lord, I require some time for filing my counter. They have filed their.
Wait for your turn.
Okay.
Yeah, please. My lord, I am praying for one matter for withdrawal tomorrow, Lordship. And Lordship, this is for withdrawal tomorrow is maybe given. And one.
Why tomorrow itself? You will have
We have some urgency because the authority is saying that if you withdraw this case, he will get the my lord.
Not
Get
tomorrow, but the day after tomorrow. First.
my lord, if possible, Lordship, to. My lord, another one motion matter, Lordship. I am praying for Lordship unlisted today, Lordship.
No,
Then tomorrow, Lordship.
I don't permit on.
Then tomorrow, Lordship. Of like.
May please, Lordship. Lordship, kindly list matter, Lordship. It will come an admission matter, Lordship, on 3rd March, Lordship.
13th.
Lordship. Sorry, Lordship.
13th of March.
Highly obliged.
May I please, your Lordship? Lordship, I beg to mention for listing for admission, Lordship. Matter related is a compensation and matter, Lordship.
Yeah, 15th March.
May oblige. May I please, your Lordship? Matter relates to GST, Lordship. Lordship, may I pray for admission, pray for listing it in the admission column day after tomorrow, Lordship.
GST matter, I think you should approach the appropriate court. Don't do it.
Yeah, 10 minutes.
My court will say. You mentioned before the appropriate court.
Oblige.
May I please, your Lordship? Lordship, I beg to mention a matter for listing writ petition, Lordship, for motion, Lordship, on Thursday, Lordship.
Why
We
Thursday?
filed on 10th, Lordship, Thursday or Friday, and Lordship. 2nd or 3rd.
Thursday.
3rd.
May
Much
please,
obliged.
Your Lordship. Lordship, item number 57, my lord, that part heard matter. My lord, can it be a 2? I have words with Mr. Borpujari also. He'll be available at 2, my lord.
We'll take
He'll take 10 minutes, he said, my lord.
subject to the thing.
My lord, at that means highly obliged. my lord.
May please, your Lordship. Lordship, this matter was fixed today, Lordship, but the same is not listed, Lordship. So my prayer is that, Lordship, kindly allow this matter on Wednesday, Lordship.
10th March.
My pleasure, Lord. Lordship, with the consent of the other side, I beg to mention item number 41 on behalf of the conducting counsel, Mr. J.C. Gogoi.
Wait for your turn. Just only the notification, you have to give 1 day in advance for adjournment.
Lordship, I'm aware of that. Yeah. Lordship.
Item 1 of daily list withdraw.
Make please, Lordship.
Yes, please.
My lord, this petitioner is a scheduled caste and 40% physically handicapped. He was working for last 12 years in a irregular post, then as officiating in a regular post. Then my lord, college, he was in a college, my lord, 4th grade. Then my lord, college authority made a advertisement without giving reservation for scheduled caste or physically handicapped. So my lord, your lordship will kindly go to page 6. Then we obtain a protection from this honorable court.
Page
The effect that
6 of the IA.
of the IA, my lord.
Yes.
The page 4,
Page 6 of the IA.
para 6 of the IA, my lord.
Para 6 of the
Notice returnable so and so, so and so. So say that college authority was directed not to appoint without taking leave of this court. Now that, my lord, 4 posts of gate 4 has been sanctioned newly. So the college authority says that you withdraw it, and on the basis of your experience and being physically handicapped, we will consider your appointment. So we are withdrawing this with a prayer that we may be granted liberty.
The IA or the
IA, only IA, my lord.
IA. Mr.
Yes, Lord.
Learned counsel, senior counsel assisted by Mr. MS
M. Bravo.
M. Bora.
Bura Gohain.
Bora Goen, learned counsel applicant. Place for withdrawal of this IA with liberty to file. Mr.
As Bhuya,
As Bhuya, learned standing counsel,
higher education lordship.
appears for higher education. IAS according to post with liberty.
Appellate.
How about the writ petition? Date is fixed.
Yes. Any day convenient to your lord.
But Mr. S.A. Pura name of I post list indicates that this is disposed.
Oh,
That is all right then, man. Appellate.
Item 2, 3, and 4, motion.
yes. Item 2, I have given that instruction lordships. Government is processing the file lordship regarding payment of area, and it will take some time lordship because the financial approval have to be taken lordship.
How about item 3?
Item 2, 3, 4, both, all the 3 items lordship. Yes, we'll pay. It is on lordship. It will take some time because the finance, we have to take the approval from the finance area salary lordships until unless the finance government.
How long will you take?
It will take after 4 weeks lordship. We have received the proposal.
It's hurt Mr. A.K. Datta, learned counsel. Mr. S.M.T. Chisti, learned standing counsel in the education part. Submits that the respondents
In a government level, in a government lordship.
are processing for payment of area salary application and is presently in the government. He therefore prays for 4 weeks time for filing compliance report. Praise allowed,
My instruction is appropriate action towards compliance of this order. Yes, sir.
place the matter before
After 4 weeks.
Item 5,
In this case, the petitioners are working as the education volunteers. They are working for last 15 years. But by impugn order dated 23/8/2020, their centers are going to be closed. This is impugn order is lordship at page 109 lordship. So in similarly situated case in Kamrup district already state the impugn order lordship.
What is this?
Also, as per court order, we annex the agreements. Impugn order is 109 lordship, annex 6 lordship. We are from the Dibrugarh district, already the Kamrup district already state lordship.
What is
Also, the petitioners working as an education volunteer for last 15 years. Their tenure extended from 11 month to 11 month for each year. And their tenure will be expired on this month, February 23. They are agreed by the order lordship. Really situated case in Kamrup district already stated by the Honorable Court lordship.
109 impugn orders.
Order
109.
30/11/2022. In similar situated case in Kamrup district lordship. Yes,
30/11/2022?
yes, similarly situated case already
My lord, he has filed an additional affidavit. That copy is not yet. We have not yet received. But it is in the office. I think he has filed it today.
Also, we have filed an additional affidavit as per court order. Our tenure will be expired on February 23 this month.
23.
Lordship.
It has already expired.
Only
Yes.
expert, so we expect tomorrow, lordship.
Oh, 28.
Yes, lordship. So we approach but similarly situated case, their cases in Kamrup district lordship, they are expired on November lordship. They are already stayed and extended lordship up to 25-26 financial year.
Which district? This is which district?
I am from Dibrugarh district. In paragraph 18 lordship, In the order dated 30/11/2022, they have extended according to the
I'm
supposed
asking you one question, you answer that
Lordship,
question. Which district are you, are we?
from
dealing
Dibrugarh
with this?
district. Dibrugarh district.
That's what I want to know.
In CL number 10, when page number 109, CL number 10. District Dibrugarh.
Yes,
Yes, please, sir. This SSA is the main party lordship. I think the impugn order was issued by the SSA.
Gogoi, we can pass the same order. My lord.
Sir, this particular order, my lord, was passed after my lord having all the instructions. My lord. It's not that, my lord, it's a final order, I suppose. Yes, it is a final order. My
It's
lord.
not a final order.
It's a final order. It's a final order, my lord. Para 23. Writ petition stands disposed of. So at least sometime may be given, I can have the instruction, my lord. Let it be on Friday.
Their term is ending tomorrow.
But my lord, if their services are not required, if the term ends tomorrow, but can they, my lord, forcibly stay under this particular scheme, my lord? That's the issue. So I will have the instruction by tomorrow in that case, my lord. Today's time may be given.
Tomorrow.
What is the status of this particular districts? Lordship may kindly indicate in the order the respective districts of the petition.
Dibrugarh district, Lordship. Particularly. NJ Gogoi.
NJ Gogoi. So, the present petitioners. How many petitioners?
Total 69 and 6 numbers of petitioners.
The present 69 petitioners.
66, Lordship.
66 are serving as education volunteers
And education.
within bracket EV and additional education volunteers within bracket AE in different non-residential special training centers within bracket NRSPCS within Dibrugarh district on contractual basis receiving fixed honorarium. By this writ petition, petitioners are praying for stay of the impugned order dated 109
23 at 22.
2022. Which provides that they will continue functioning only till mainstreaming of the children. And with regard to Dibrugarh district, the schedule for mainstreaming of children is up to February 2020. But Mr. B. Gogoi, Leonard, standing counsel has pressed for the day's time to receive instructions in the praise the Lord. This the matter again on
Tomorrow at 2, my lord. At least I will get some time.
tomorrow's what day? 28th.
Tomorrow is the 28th.
On 28th February 2022 at 2 p.m.
My lord.
Highly blessed.
Say,
May I please, your lordship? Lordship will find the order at page 10, my lord. At page 10 and dated 16 March 2022, my lord, and operative person, your lordship will find at page, next page, page 11. No, sorry, not page 11, my lord, page 14,
Yes.
paragraph 10. To the director, my lord, within 2 months, but till date, my lord, almost,
But Mr. B.K. Dekas.
yes, my lord.
Issue nothing. Petitioner takes steps for service of notice by registered post within 1 week. list matter.
7,
My lord, in item number 7, my lord, in page 2, my lord, inadvertently, my lord, we're supposed to make implemented secretary instead of director, my lord. I may be allowed to rectify it, my lord, correct it, my lord. Page 2, my lord. The appellate authority is secretary, my lord. Here we have made part of director, not director, my lord. So I may be allowed to correct it, my lord. Or your lordship may fix it on Wednesday, my lord, so that I could correct, indemnity correct.
Learned counsel for petitioner is permitted to correct the address of the sole respondent
Yes, my
in the present content petition before the joint register judicial and list the matter again of the day after tomorrow will be difficult, I think,
Day after tomorrow, my lord.
on second.
My lord, deeply obliged.
8,
But the same issue, my lord, Lakhimpur district. my lord. So tomorrow, my lord, that too, I will have the instruction. But here, my lord, it is the Lakhimpur district.
Yeah, Mr. T.K. Muni.
Yes, my lord. My lord, here lordship has passed an order in this case of similar to district of Lakhimpur, my lord. If I may place it before your lordship.
That I've seen, anyway,
But in their case, my lord, January was the last date. So we are in February and my lord. So that period is already over, but even then I will have the instruction by tomorrow, my lord.
are you still continuing?
But my lord, we are still continuing. I had a word with my clients yesterday, my lord. They are still continuing. But it was supposed to be closed by the end of January. But it hasn't been done till date, my lord. But apprehension is there that they might close down. That is there, my lord. And similarly situated petitioners, my lord, people from the district of Lakhimpur has already approached this court and my lord has passed this order, my lord. This court, my lord.
Scheme to জানেন নাকি কোনোবা স্কুল পুরা বয়সৰ ল'ৰা ছোৱালী যদি ঘূৰি আছে হয় বিচাৰিব লাগে আচ্ছা স্কুল চাব যেতে আপুনি 6 বছৰ ক্লাছ পাব 8 বছৰ হৈ গ'ল
From same district, Lakhimpur.
But Mr.
P.K. Munir.
P.K. Muni, learned counsel for the on request made by B. Gogoi, learned assessing counsel, assistant, list the matter again on 28 February at 2 p.m.
At 2 p.m. Obliged.
9,
Make legal lordship. My lord, it's related to the compensation department lordship. Lordship, SLC has rejected lordship, DLC referred lordship. Only the period of lordship,
Where is the SLC?
SLC lordship page 43, operative portion lordship. My name is page 43 lordship, serial number 2, Saiful Islam. State level committee rejected the candidate, page 43. Last paragraph, lordship. State level committee rejected the candidates on the ground that the remaining service period of the deceased government employee was less than 3 years. Lordship, these 3 years, lordship, as per by virtue of 2015 circular, that clause was set aside by this honorable court.
Where is that order?
I have annexed that, lordship.
Page number 56.
Page 56, lordship. Operative portion of the order, page 76, lordship. Paragraph 19, lordship. Of the said judgment, lordship. In with this court answers the issue number 1 to the effect the clause 1 of the opposition where deponent family members of the government official who page 76.
Yes.
Paragraph 19, lordship, may I kindly read.
Where's the DLC minute?
DLC minute, lordship. Just I refer, lordship.
Page 27.
Page 43, lordship.
43 is SLC.
Lordship. That is the, oh, sorry, DLC minor to Lordship. It's Lordship, DLC minors, Lordship, page 28,
20.
Lordship.
Yes. Where's your case?
My name is paragraph A, Lordship. See, Saiful Islam so and so applied for the post of so and so on the compensation. The said proposal was earlier placed, but was not recommended as the disease did not have minimum 3 years of service at the time of his death. But now the DLC minorly perused the said case and as per Honorable High Court's order dated so and so recommended the said proposal for the post of grade 4 pre-service pre-senior Madrasa under this his parent department. Then Lordship, while the this honorable court, while setting aside that clause, Lordship, also disposed the matter, Lordship. I have placed the same line of order, Lordship, page 83. That is less than those who have less than 3 years service, Lordship. Again, refer to the SLC, Lordship, page 43. Some of the analogous matter already. Page 83, sorry, 83. 83, Lordship.
Yes, okay. Yes.
I pray,
Baba.
Lordship, on the same line, this matter may be disposed, Lordship.
Heard Mr. K. Majumdar and the counsel for the petitioner. Also heard.
Give me 1, 2.
And for 1 and 4.
SMT still understanding counsel, secondary
Second.
education for respondents, 1, 2,
2, 4,
4,
1. 1, 2, and 4.
1, 2, and 4.
Yes, sir.
And MSDD Barman, the governor for respondents,
3, 5, and 6, sir.
3, 5, and 6. Stop. For petitioners for let Manjil Ali Sheikh while serving as a grade 4 employee in Kulamuya, Nichinpur High School, Dhubri, died in harness on 36/2000. The petition made an application on 8/9/2000 for appointment on competition ground to any grade 4. The district level committee in its meeting held on 28/12/2021, correct?
Lordship, 28/12/21, Lordship. Page 27, Lordship.
Recommended the case of the petitioner. For appointment to a post of grade 4 in pre-secondary oblique pre-senior
Lordship.
pre-SR oblique SR Madrasa under his parent part. The state level committee in its meeting held on 1/3/2022
Sorry, Lordship, it may be signed was on 31/3/2022. Page 53, Lordship.
in its meeting held on 1/3/2022 rejected the case of petitioner on the ground that the remaining service period of the deceased government employee was less than 3 years as he had only 2 years, 6 months, and 1 day before his retirement. Stop. But, no, it appears that the said recommendation was made on the basis of clause 1 of the office memorandum dated 1
Lordship, it is that office memorandum I have annexed to the 1st June 2015.
issued by the Department of Personnel D in Governor.
Timing, comma.
This court by judgment and order dated 31/2023 in WC 1646/2021 another batch of litigation struck down clause 1 of the office memorandum dated 1/6/2015 on the ground that it violates Article 14 of the Constitution. Para. A perusal of the meeting minutes of the SLC dated 1/3/2022. No, stop. In that view of the matter, the matter is remanded back to the state level committee to reconsider the case of petition after in its next immediate sitting by keeping in mind judgment order dated 31/22 passed by this court in WBC 1646/2021 and other batch of petitions with the above.
Much obliged, Lordship.
10.
May I please, Lordship? Lordship, same matter, my lord, it pertains to compassionate appointment. My lord, the minutes of the district level committee, page 16. My lord, DLC Gwalpara has rejected my case, my lord. It starts from page 16 and my case is at page 25, my lord.
Yes.
My lord, page 25, my lord, below the table, my lord, serial number 7, Sheikh Arifud Zaman. And my lord, in the remarks column, my lord, date of birth of the government servant as mentioned in the application was so-and-so. As per point number 1 of the OM number so-and-so dated 1/6/2015, the government servant must have minimum balance of 3 years of service. So my lord, in view of point number 1, my lord, my case was rejected. And this is also covered by this judgment of 31.
This is a minute of 2018.
2018, my lord, where the judgment was passed on page 80, my lord, see,
Page
page 84, my lord. I'm sorry, my lord, page 89. This court also considered the case of 2016 also, my lord. Page 89.
yes.
My lord, in the instant repeated petitioner has assailed the minors of the district level committee held on 26/05/2016 insofar as rejection of the petitioner's application on the ground that the petitioner's father had less than 3 years of service. The said rejection is interfered with and thereby directing the district level committee for compassion to reconsider the case of the petitioner without insisting upon the compliance to clause 1 of the office memorandum.
Yes, Form
Yes, Lordship. This case has been filed in 2022, Lord.
but this is the same matter.
Same matter, 2016. Remanded.
Mr.
M. Ali, my
Emily also heard Mr.
G paper, Lordship. G paper.
G. Beko, General Standing Council, Elementary Education Department.
Yes.
Correspondent,
One.
1 and 4.
1 and 4 months.
NMS DT Barman, London. Government Advocate,
Alright,
correspondent.
2 and 3, Lordship.
2 and 3. So, para the father of the petition. Let Abul Kasimia, while serving as assistant teacher at Dambari MU School in the district of Bolgar. Died in harness on 6/4/2000. When did you make your application?
My lord, the application was made on 4/2/2017.
The petitioner draft made an application on 4/2/2017,
17.
praying for appointment on computer. The district level committee in its meeting held on 23/2/2018 rejected the case on the ground that the father of petitioner is this a case of rejection here?
My lord, page 25.
That's why I'm on page 25.
My lord, the list of rejected application in respect of DO, my lord,
On the ground that the father of the petitioner had less than 3 years of service on the day of the so, and accordingly his case could not be closed. Then you continue that same order. Then in the last para, accordingly, matter is remanded back to the district level commission.
Goalpara.
Goalpara, for reconsideration of the case of petitioner after. Same thing.
Next committee. Obliged, lordship, highly obliged.
54 of supplementary list.
54. Lordship, this matter may kindly taken after Stanton. Advocate General will appear in this case on behalf of the state government, Lordship. He is on legs at court number, I think 11. So after some time, Lordship.
There will be one more connected matter.
Item 13 of daily list.
Both the items will be taken
Both the
together.
items will be taken up together. Same issue.
54 and 13.
13.
1
13 is an IA.
Yes.
There is an IA there.
55.
May I please the lordship, my lord. My lord, the petitioner's post was provincialized as a head teacher along with the private respondent number 5 as assistant teacher in the year 2014, my lord. Kindly turn the page 15, my lord, provincialized order. Turn 15, my lord. Serial number 97, my lord, left. Season Gram block, my lord. Ghoramara LP School. Date of establishment 1/1/1982. Next, my lord, Sulaiman Hussain, AST, head teacher, present petitioner, my lord. Date of joining, my lord, 12/8/1985. Next line, my lord, Bahar Ali, AT, assistant teacher, my lord. Date of joining 27/1/1989, my lord. Then, my lord, kindly turn to page 18, my lord, Annexure 2. Annexure 2, my lord. Page 18. Order dated 3/11/2022. Transfer order was passed, my lord. As per report received from the BEO Srijan by letter number so and so. Sri Sulaiman Hussain, head teacher of Pub Ghuramara LP School, is hereby allowed to work at 683 number Ghuramara LP School as a head teacher. Next line. Accordingly, Sri Dilip Kumar Das, IC head teacher of 680 number 3 Ghuramara LP School, is allowed to work as a head teacher of Pub Ghuramara LP School with immediate effect. But in his place, another teacher was allowed to work, my lord. Kindly turn to next page, my lord. Annexure 19, my lord.
Yes.
My lord, the petitioner went to join in that school, my lord, particular school, but the local people and SMC of that school are not allowed to joining, my lord. This is information to district block elementary education officer. My lord, then next page 23, my lord, annexure 5. 5, my lord. In connection of this office order number so and so dated 3/11/2022 and BOS order number so and so dated so and so, Sri Bahar Ali, assistant teacher of Pub Ghuramara LP School, is hereby allowed to work as a IC head teacher of the school until further order. Next line, my lord. The earlier order issued by this memo number so and so dated 03/11/2022 is hereby cancelled. My lord, the earlier transfer order is cancelled. And the assistant teacher, Bahar Ali, is allowed to work as a head teacher.
And you are?
I am demoted, my lord. My lord,
Notice should go existed because this impunity is the 1st of February. Perhaps that the other respondent has already joined his posting law.
no, my lord. At present also he is working in this post, my lord.
No. That have
My lord, kindly turn page to 26, my lord.
not
It's
even the
24, my
status
lord.
quo may given no.
24, my lord. 24. Dated 10 February 2023 to Sulaiman Hussain, head teacher, Pub Ghuramara LP School, regarding charge handover. My lord, 10 February passed an order for handover the charge to the assistant teacher of the present petitioner's school, where present petitioner is working as a head teacher. He is junior to me also, my lord. 3-4 years. And another order also passed, my lord, after filing this
In that way, the
petition.
petitioner is not deserving the higher authority order lawsuits.
22
Should have been handed over the served
23, my lord. Another order also passed, my lord.
Okay. Heard.
My lord, kindly stay the
Yes, your good name, please.
Am Islam, my lord.
M. Islam Learned Council for Petitioner. Issue not. Mr. Learned Standing Council. Second page.
No, it's elementary case law. So elementary for 1, 2, 3, and 4.
Page 4, no 1, 2,
3 and 4.
Petitioner takes step for service of notice on reform number 5 by registered post within 1 week from the date. Respondents are allowed to extra copies you furnish.
Yes.
List the matter for which
My lord, pendency of the
No
Till
stay order should be
till the next reasonable date. Parties are directed to maintain status quo as on.
my lord, annexure 5 and 6 may be statement.
I've said status quo. I don't know whether you have handed over chart or not.
11 of daily list, they were getting application.
11.
My lord, in this matter, my lord, I am led by Mr. Kayan Chaudhary, my lord. He is on legs, my lord. Kindly pass button matter for time being, my lord. My lord, after some time, my lord.
Here, my lord, your lordship, last occasion, your lordship was supposed to remand the matter to the director, my lord, because the matter has not yet been finalized by the director. So only issue was, my lord, the private respondent was not appearing. Today he is appearing, my lord. That's why your lordship was not this matter, remanding the matter. Otherwise, my lord, the similar orders, your lordship has passed numbers of similar orders, my lord, where, my lord, the selection committee has recommended, but the director has not approved. So it is not yet finalized. So being premature, your lordship has remanded all the matters.
Which rule is that? 2018 rule,
Yes.
is it?
This is relating to higher.
It's relating to higher education.
Higher education.
Director is supposed to take steps within 1 month, isn't it?
But my
Yes,
lord, our claim is, my lord, there are two selection process was there, my lord. Earlier it was challenged, my lord. It was set aside, my lord. Then the matter was remanded back to the college authorities, my lord. They have conducted a fresh selection process within those candidates, my lord. But my lord, the documents which were earlier considered, my lord, this time some documents were not considered, my lord. Therefore, I was given 0 mark, my lord. Earlier, I was given 4 marks. After some time, my lord. Obligation.
12.
May it please your lordship.
May I please your lordship? My lord, this IA copy I received on Friday, so I need some time to file my counter, my lord. Let it be listed.
My lord, today two different I listed, my lord. Lordship, I have filed the IA on 1st of February, my lord. Today for third time the matter is listed. Otherwise, lordship, the petitioner has no objection in respect to the IA filed by me, my lord. Because I am claiming for
Petitioner,
Yes, yes.
what objection do you want to file?
against IA number 289, they do not have any objection, my lord.
289, I don't have any objection, but I do have my objection for the last IA filed by another party, my lord, 482.
Both of us are included
I think
respondents.
Both of you are there.
Where both of us are included respondents, he filed his IA separately and I filed.
How much time you require?
well, 10 days time.
Okay.
1 week or 10 days.
1 week time I'll give.
Lordship, in that case, lordship, let it be fixed on 15th of March, my lord.
Okay. You are Mr.
R. Karim.
R. Karim, learned counsel to the applicant in IA 289 of 2023. Also heard Mr. M. Sharma, learned counsel for the applicant in IA 482 of 2023. Okay. Mr. J. Abidin, learned counsel appearing for the respondent in
Petitioner, your lordship.
opposite party, isn't it?
Opposite party.
Yes, my lord. Petitioner opposite party.
Opposite party number.
One.
You want to file your objection in 482.
Yes,
Opposite party number 1, your lordship.
Opposite party number
1, your lordship.
1/1 petitioner. Praise for filing objection in IA number 482 of praise Allah. This the matter on 15th you want.
15th, my lord.
15th of March.
Oblige,
Deeply obliged.
lordship.
14. Admission.
In 14, also, both of us have some difficulty. Lordship. We are unable to trace out our file. He is also unable to trace out his file, lordship. So after next Monday, lordship.
My lord, similar is with, I am also today briefless, my lord. My lord, matter relates to selection and appointment of teachers in Madrasa institutions, my lord, when these institutions are surviving, my lord. The government has initiated a process for the purpose of filling up the posts, my lord. But when the process before culminating logical end, my lord, the government has revoked these Madrasa institutions into general schools. But, my lord, the posts these institutions retaining, and those has not been abolished, my lord. So therefore, we want the selection process which was initiated should be logically culminated, my lord. As my learned friend has difficulty, my lord, may fixed on next week, any date, my lord.
Any date next
Some
week.
urgency is there, my lord.
On request made by the party. Otherwise, you are ready.
My lord, on next week, I can.
No, today you are ready.
Today I am not ready, my
He's
lord.
also
On request made by the party. Please respond. Next week will be either 9 or 10. It's up to
My lord, any date, my lord,
Any-
as per convenience of my lordship, my lord.
9th of March.
My lord. Obliged.
15.
15, lordship, we need some accounts because others modules and his elder daughter his metric is exam started today, lordship. So he is unable to come today, lordship. Mr. R. Modundar, lordship. He is handling this case, lordship. So he requested me to take some time, lordship.
My lord,
How much time?
next week.
Any day.
Hurt, Mr.
BM, my lord. On behalf of you can.
BM Deka, my lord, on behalf of UK Nair.
On behalf of the UK Nair, on request made on behalf of Mr. R. Martin. Standing counsel,
Secondary.
secondary
Elementary, so lordship elementary.
elementary education. List the matter after 1 week.
A week.
1 week, my lord. That may be fixed, my lord.
12th March.
12 March. My lord, 12 March, my lord.
Yes.
Yes.
I think it's Sunday. It's
12 to Sunday.
Oh, 12 is not.
12 is Sunday.
12 is Sunday.
15.
Yes, yes.
Much obliged, my lord.
May
please, your lordship.
In this case, we have
In
filed
this case,
You filed your affidavit?
Yes, ma'am.
yes, my lord. Director has already filed affidavit, my lord. And the personnel be also filed.
Personal also is filed.
My lord.
You want to continue or you want to file your reply?
My lord, the reply is not required in this case, my lord.
Okay.
Here, my lord, the husband of the petitioner was killed by the extremist on 27/4/1998. Then, my lord, the petitioner, being wife of the deceased, my lord, applied for job on 7/11/2000 under a rule, my lord, that is Assam Public Services Appointment of Family Members of Persons killed by extremist terrorist rules 1992.
Where's that rule?
That is, my lord, page 28, my lord.
Yes.
Here, my lord, in definition 2A, affected candidate is, my lord, defined, my lord. And family is defined at D, my lord, 2D, page 29. Issue herein, my lord, is that whether this rule is applicable to education department or not. That is the issue in this case, my lord. Now, my lord, your lordship may kindly see rule 3, page 29, application. These rules shall apply to all the services and posts under the government of Assam, recruitment to which is made through the commission or otherwise than through the commission. So, my lord, it is applicable to all the departments of government of Assam, my lord. Now, my lord, procedure of appointment, my lord. Rule 4. Subject to the provisions of these rules, whenever any recruitment to services and posts referred to in Rule 3 is made, only one affected candidate from one family who applies and is eligible under the normal rule will be given appointment to a government job or job under state government undertaking or board. Before making any application, making any appointment, the appointing authority shall ascertain from the deputy commissioner of the district of the person who was killed in violent activities that no other member of the family of the persons killed in violent activities has been appointed under sub-rule A of these rules or in accordance with the directives or instructions of government for appointment of affected persons to any government job or to any job under each public sector undertaking, company, corporation, etc. Now, my lord, procedure for selection is rule 5. It is important. A panel shall be prepared by government in personnel A department out of the applications obtained by deputy commissioner, subdivisional officer from the families of those killed by the extremist or militant. The panel for various categories of posts shall be prepared by sifting the applications and looking into the qualification, etc. of the applicants. Every government department, public sector undertaking, board authority shall be required to make appointment from the panel till such time as the panel shall be exhausted in respect of candidates having requisite qualification for different grade of job, provided that in cases where there is no family member with requisite qualification for any government job, the minimum educational qualification for the lowest category of jobs, grade 4, should be relaxed and such a family member may be appointed to grade 4 jobs, provided further that for the post under the purview of the commission, the list of suitable candidates shall be sent to the commission for necessary recommendation. Now, there is a provision for relaxation in Rule 7 and Rule 8, page 32, my lord.
This is giving, my lord, overriding effect, my lord. Notwithstanding anything contained in any normal rules for recruitment to the service and post referred to in Rule 3, the provision of this rule shall have overriding effect. Now, my lord, under this rule, the petitioner have already applied, my lord, for the job. And my lord, her application was recommended by Deputy Commissioner, that is filed annexure 4, page 37, on 26/8/2002. Page 37, my lord. Thereafter, due to the inaction of the authority, my lord, the petitioner has approached this honorable court by filing WBC number 9575 of 2003. And same has been disposed of, that is by the order, my lord, annexure 5, page 40, my lord. Order dated 14/12/2004, whereby, my lord, process was directed to be expedited, my lord. But what happened, my lord, in the meantime, that rule has been repealed.
Which
That-
rule?
That APS rule is 1992. That is filed, my lord, notification, page 45, annexure 6. With effect from, my lord, 22nd June 2004. And a new scheme has been introduced by annexure 7, page 46, my lord. 46. By this new scheme, my lord, provisions for preference in government job has been made and ex gratia amount has been enhanced from 1 lakh to 3 lakh. But, my lord, height annexure 8, page 48, my lord, this new scheme has been made prospective, my lord, given prospective effect, page 48, my lord. But even, my lord, thereafter, the respondent authority neither considered our application for appointment since rule has been repealed, nor considered under the new scheme, my lord, for enhanced, my lord, ex gratia amount. Some of the, my lord, persons, affected persons has approached this honorable court, my lord, by filing writ petition, my lord, in this regard. And this honorable court has been, my lord, disposed of that writ petition, my lord, that is WBC number 3355/2007, whereby, my lord, the persons who has applied prior to cutoff date of 22/6/2004, their persons have, my lord, declared eligible for appointment under the earlier rule, my lord. And the person who have applied thereafter, my lord, they are not eligible for appointment under the rule, my lord. They are entitled to the, my lord, enhanced amount of ex gratia. Now, my lord, on the basis of that judgment, the office memorandum dated 29 July 2013, that is, my lord, annexure 9, page 49, has been issued by the personnel department. Married, my lord. The state government have examined the matter relating to giving relief to the families of persons killed in extremist violence for quite some time. Many persons have already approached High Court for getting relief either under APS Rule 1992 or under guideline issued by, my lord, that is new scheme 22/6/2004. The Guwahati High Court has also issued direction in many such cases declaring that the provisions of 1992 rules will be applicable in cases where applications for government job were made prior to June 22/2004. On several occasions, government has implemented decisions of High Court in individual cases, while the fact remains that lots of similar cases are in existence awaiting decisions. A detailed examination of matter was done in the light of High Court's order in the WBC number 3355 of 2007, Sri Dhaneswar Bosumotari versus State of Assam, where the High Court held that applications for appointment to government post made prior to 22nd June 2004 would survive even after coming into force of new policy in 2004. The government have examined the judgment carefully and decided to implement the same in an expeditious manner. 2. Government in personnel department have prepared a list of applicants who have submitted applications for job prior to 22nd June 2004. That is the date in which the APS rules of 1992 were repealed. On the basis of the information received from the Deputy Commissioner, The list contains the names of 57 such applicants and in appended at Annexure 1. A similar list of applicants has also been prepared containing names of persons who were killed prior to 22nd June 2004. But those whose relatives had not applied for any government job prior to 22nd June 2004. This list contains names of 63 such persons and appended at Annexure 2. Here, my lord, no list has been prepared in respect of Nalbari district. Petitioner is a resident of Nalbari district, my lord. Now, 3, my lord. Now, in pursuance of Rule 5 of the aforementioned rule, this list as at Annexure 1 is enclosed herewith, which is to be verified carefully by all government department, public sector undertaking, board authorities, etc., as the case may be, and as required under Rule 4.2, and immediately appoint the applicants who are found genuine and otherwise eligible as per the aforesaid rules to the first available vacant post in their respective establishment. Now, my lord, procedure. Rule 4, my lord. Considering the fact that the Deputy Commissioner may face undue hardship while verifying the cases received from various government departments, public sector undertaking, board authorities, etc., the government in exercise of power under Rule 7 provides that the Deputy Commissioner having to dispose of such applications for verification will constitute a committee to oversee the genuineness of the candidates and place the applications for appointment before a committee.
Yes, that's great.
My lord, here under sub-rule 3, my lord, the applicants whose applications were not available before the authority, if they are found later on, my lord, they are examined and subsequently recommended by Deputy Commissioner. Our case has also been, my lord, recommended, my lord, that is Annexure 11, page 52, my lord. Here, my lord, minutes of the meeting is at page 53. In bottom, my lord, I am Mithu Devi. Right, my lord, this minutes of the meeting dated 22/3/2017. I have been recommended to a post of elementary education department, my lord. There was 67 numbers of vacant posts, my lord. Out of those posts, I was recommended for 1, my lord.
Yes.
Now, my lord, thereafter,
Yes, serial number 1.
my lord, I am serial number. Thereafter, my lord, District Elementary Education Officer has forwarded the same to the Director of Elementary Education. Annexure 55. And thereafter, my lord, the Undersecretary, my lord, Annexure 13, sent back to the Deputy Commissioner for re-examination of the case, my lord. And the Deputy Commissioner, after re-examination, again, my lord, forwarded the same height Annexure 14, page 57. Thereafter, my lord, the Director, my lord, Elementary Education Department, sought some, my lord, information in formats, my lord, from the District Elementary Education Officer, height Annexure 15, page 58. And SAM has been, my lord, submitted by DEO to the Director, height Annexure 16. Here, my lord, at page 63. My name has been, my lord, reflected. Page 53, my lord. 63, sorry, my lord. Mithu Devi, my lord. That's serial number 1, my lord. Then, my lord, the Director submitted the same to the, my lord, government, my height Annexure 17, page 70. And the government again sought some, my lord, clarification, my lord. And in response to which, my lord, Annexure 19, page 72, Director has submitted the details as per format sought by the, my lord, government. Here also my name is reflected in page 74, my lord. In 74, my lord, the details of 2 schools regarding sanction number, creation number has been forwarded, my lord. Now, my lord, thereafter, page 75, my lord, Annexure 20. The government has rejected the proposal, my lord. This is the impugn order, my lord. May I read, my lord? In inviting a reference to the above, I am directed to inform you that the government in elementary education department observes that sanctioned vacant post cannot be filled up by nomination of persons as the proposal demands. Sanctioned vacant post can be filled up only with the concurrence of finance department, then due procedure of selection through advertisement of the post. Applications from eligible candidates may be received, and then among the candidates, competitive examination is to be conducted to find out the selected candidates to be appointed. Hence, this nomination for filling up of sanctioned vacant post is regretted. This is issued as per endorsement of finance department. My lord, my humble submission before your lordship is that since the APS rule is made applicable to all the departments, this rule is also applicable to the, my lord, education department. So cannot, my lord, avoid the responsibility by this, my lord, impugned order. And thereafter, my lord, since this, by this, my lord, order rejected a claim of two persons, my lord, one Deras Talukdar and another myself, my lord, we have jointly approached this honorable court, my lord, by filing WPC number 485 of 2021. But this honorable court, my lord, had order dated, my lord, 18/8/2021. Your lordship may kindly see paragraph 2, page 77, my lord. May I read, my lord? Two persons, namely Sri Deras Talukdar and Srimati Mithu Devi, have approached this court by filing this common writ petition, raising a grievance that their respective predecessor in interest had died in extremis violence, and therefore they are entitled to an appointment in a government job under the APS rules 1992. The respective legal rights to be appointed under the rules of 1992 would be individual rights depending upon the individual facts and circumstances. And therefore, prima facie, we are unable to accept a joint petition by two separate claimants for such appointment. We have noticed that in this writ petition, the affidavit has been shown by the petitioner Sri Deras Talukdar. Accordingly, we entertain this writ petition on behalf of the petitioner Sri Deras Talukdar and dismiss the petition on behalf of the other petitioner Srimati Mithu Devi by giving liberty to approach again if so advised. Accordingly, my lord, I have filed this writ petition under this liberty, my lord. And this earlier writ petition has been, my lord, dismissed in respect of me, and my lord disposed of in respect of Deras Talukdar, remanding back to the Deputy Commissioner for re-examination, my lord, because some new facts has been, my lord, pleaded by the respondent, my lord, that his application was not genuine and doubtful, my lord. And that is why it was remanded back to the Deputy Commissioner for re-examination. Now, my lord, another annexure, my lord, annexure 22, page 84. By, my lord, same minutes of meeting of the Deputy Commissioner, my lord, these persons were also recommended to other departments, my lord. And they have already been appointed, my lord, in the year 2018. But we have been left out, my lord, since we are recommended to the elementary education department, my lord. So my humble submission is that, my lord, that impugned order is not tenable in the eye of law, since, my lord, this rule is applicable to all the departments. This rule is also applicable to the education department. My lord, that is why, my lord, we are required to be considered under the APS rule 1992. That is my humble submission.
In this case,
Yeah.
in this case, lordship, the education department, lordship, they will repeat this, no?
My lord, we have filed affidavit.
Yes.
My lord, we have filed our affidavit, my lord.
Which affidavit? There are two affidavits here.
On 14/11/2020, my lord.
By this affidavit, my lord, entire facts has been, my lord, admitted. But, my lord,
14/11/2022, as per my.
Response number 5.
yes, my lord.
Yes, ma'am.
Yes. Then
Hereby, my lord, entire facts have been admitted by my lord. But whether this rule is applicable or not, that has been left to the, my lord, government, over government, my lord. By paragraph 12, page 6, my lord.
Page,
Page 6, my lord, internal page, paragraph 12, my lord.
cutoff,
Paragraph 12, my lord.
This affidavit has been filed by the director, my lord.
and the other affidavit,
That is, my lord, by personnel be, my lord.
personal be, who appears,
Personnel.
On 8 February 2022.
yes, what do you have to say?
In paragraph 5 of my affidavit, lordship, in this case, lordship, only notification, lordship.
Huh?
Paragraph 5, lordship. That the respondent number made in paragraph 8, 19 of the answering upon it is a fact that Assam Public Service Commission has repealed the government on 22/6/2004, and new set of guidelines was issued in place of said rules to give relief to the affected families. So answer dated 22/6/2004. This was communicated to all deputy commissioner in the matter of enhancement of existing. The government has issued another letter bearing number so and so and 5/8/2004 with reference to letter number so and so dated 22/6/2004, stating that the measures as prospective, and the cases which have been already decided as regards SDCR payment, etc., before the issuance of the letter should not be opened again. That in following the said letter, the Revenue Disbursement Department has also issued specific notification stated that revised amount will be applicable only in respect of person skill after 22/6/2004. That is the hours.
That is your,
Personnel department, lordship, only the notification they have issued, lordship.
At paragraph 7, my lord, they have admitted the office memorandum, my lord, which was issued by the department itself, my lord. Page 2, paragraph 7, my lord. That is the, my lord, office memorandum, whereby, my lord, reconsidered our application, my lord.
As per judgment of the honorable courts, lordship.
yes,
But, my lord, silent whether in the main issue, my lord.
and the
Whether
respondents are here.
Finance.
Finance,
Here, apparently from this documents, madam, that has been annexed to the petition, it appears, madam, the name of the petitioner was duly recommended. And a specific department was also earmarked, that is the education department for appointment as a grade 4 employee. Now, my lord, by this impugned letter at page 75, page 75, my lord.
yes,
The recommendation or nomination has been, my lord, rejected on the ground that, my lord, the petitioner cannot be accommodated in a sanction post without there being a selection. Whereas, my lord, the scheme says that, my lord, there will be a committee, they will verify. And, my lord, whatever applications were, my lord, submitted by the victim's family prior to, my lord, repealing of that act will also be covered. They are protected even by the orders of the honorable court. So, my lord, probably, my lord, this ground, my lord, they will have to justify, my lord. Otherwise, seems, my lord, they have gone for a regular selection. They have held that, my lord, they will have to participate on merit, he will have to be selected. If that be the case, my lord, the objective of the scheme gets frustrated, my lord. Totally against the scheme. And on top of that, if your lordships may kindly see, page 49, the office memorandum of, my lord, 29th of July 2013, which is prevailing as on date. Annexure 9, page 49. Lordship will see, my lord, the sixth line, my lord. The Guwahati High Court has also issued directions in many such cases, declaring that the provisions of 1992 rules will be applicable in cases where applications of government jobs were made prior to June 22, 2004. Here in the present case, if your lordship may kindly see page 38. This is the letter of the Deputy Commissioner who is the competent authority to receive the application and to forward it to the government. Lordship, may I read the para, small para? With reference to the subject above, I have the honor to forward herewith an application in original submitted by Mithu Devi, that is the writ petitioner hearing, in the district of Nalbari, praying for appointment under APS rules 1992, along with connected documents for favor of your kind information and necessary action. This is of 2002. So prior to the repeal of that particular rules, application was admittedly received. The finance department instruction is that, my lord, if the proposals comes, my lord, they will consider otherwise, because there is a specific order of this honorable court too, that, my lord, they will have to be considered. Yes, elementary. How do you justify your impugned order? Page 75.
Yes, 75.
Mr. President.
No. My lord, para 11 of this is our affidavit. My lord. Page 6, my lord, of our affidavit. The next.
How do you justify this statement? Para 11 and the impugned order, page 75.
Yes.
Do you justify?
My lord, this is issued as per endorsement of Finance Department issue conveyed in under 568 of 2020, dated 16/12/2000.
UK da,
My lord.
heard UK da, then it comes up. Also heard Mr.
I am appealing for respondent number 1, 2, and 6, Lordship.
MSDT Barman for respondents 1, 2, and
6, Lordship.
6. G. Peku for the respondents 3 and 5. And Mr. B. Gogoi, then standing counsel finance for the respondent. It is the case of petition that her husband was killed by the extremists on 27/4/1998. And accordingly, she made her application for appointment to a grade 4 post on
7/11/2000.
7/11/2009,
2009.
2009.
No, my lord,
2000.
only 2009.
Oh, 7/11/2000.
My lord.
Under the Assam Public Services, open bracket, appointment of family members of persons killed by extremists, terrorists, close bracket, rules 1992, within bracket, here and after, rules of 1992 in short. So, well, the rules of 1992 was enacted by the government of Assam under the proviso to Article 309 of the Constitution of India, regulating appointment in public service under the government of Assam of the next of kin of persons who have been killed in violent activity in the hands of the extremists since 1/1/1990. The Rule 3 provides for the application of the rules of 1990. And it states that the rule shall apply to all the services and posts under the government of Assam, recruitment to which is made to the commission or otherwise then so, Rule 7 provides for election, wherein it provides that where the government is satisfied that the operation of any of these rules causes undue hardship in any particular case, it may dispense with or relax the requirement of that rule to such extent and subject to such conditions as it may consider necessary for dealing with the case in a just and equitable manner, semicolon, provided that the case of any person shall not be dealt in any manner less favorable to him than that provided in the Rule 9 provides for overriding provision.
Rule 8, my lord.
Rule 8. And it states that notwithstanding anything contained in any normal rule for recruitment to the service and post referred to in Rule 3, the provisions of this rule shall have overriding. Para. The Deputy Commissioner Nalbari, by a letter dated 2002, addressed to the Commissioner and Secretary to the Government of Assam, Personnel B Department, stated, forwarded the application made by the petitioner for appointment under the rules of 1992, along with connected document for favor of along with for favorable action. So, as no steps were taken, petitioner approached this court by filing WBC 9575 of 2020, which was disposed of by order dated 14/12/2004, directing the respondent uh, don't say directly, with the following observation and directly. Huh? Page 44, 8 minutes. But in the meantime, by notification dated 22nd June 2004, the rules of 1992 was repealed. By a notification dated 22nd June 2004, issued by the Department of Personnel, the Government of Assam, the rules of 1992 was repealed. Draft, the Department of Personnel, the Government of Assam, issued office memorandum dated 29th July 2015. No, not this one. Where's that other notification? Which provided for
Subsequent scheme is at page 46, my lord, in Excerpt 7.
draft by a communication dated 22nd June 2004, correct?
My lord.
The Commissioner and Secretary to the Government of Assam, Department of Assam Personnel B Department, issued a notification providing that notwithstanding such repeal, comma, no, comma, anything done, comma, any order made or action taken in section June. Don't say cancel that. You are not asking for ex gratia.
No, my lord.
So this is not relevant.
Not really.
Then on repeal of the rules of 1992, an issue arose as to what would be the status of the applicant who had met the application under the rules of 1992 for appointment to a government job met prior to 22/6/2004 when the rules were repealed. Stop. Division bench of this court by judgment and order dated 9/6/2010, correct?
My lord.
Passed in WBC number
3355 of 2007.
3355 of 2007,
That was reported in 2003 GLT 443, my lord.
reported in 2010 3 GLT 443. Held that as there existed a right to make an application under the rules of 1990 prior to the said rules being repealed, the right to consider such applications also survive, and such applications cannot be rejected merely because the rules of 1992 should repealed by the notification dated 22/6/2004. So, but as the petitioner, yeah. As the petitioner, no, under the petitioner who had met her application prior to the repeal of the rules of 1992 claims. When did you make your application?
My lord,
When did you make your application?
application was made on, my lord, 7/11/2000, my lord.
2000.
My lord.
Then you cancel the project. Under the circumstances, the petitioner claims that as she had already met her application for appointment on 7/11/2000, prior to 22/6/2004, when the rules of 1992 was repealed, the right to be considered, she has a right to be considered for an appointment under the for an appointment to a government job. But where was the memorandum?
House memorandum, that is page 49, my lord. Annex 9.
Yes. The principal secretary to the government of principal B department issued office memorandum dated 29/7/2013, wherein reference is made to a list of 57 such applicants who had submitted their respective applications for appointment prior to the cutoff date of 22/6/2000. In the said office memorandum, it was provided that upon proper verification of the genuineness of the enlisted person, the persons enlisted in the list of 57 would be provided with appointment. Sapara. Clause 4. Within bracket
Purpose 3.
3. Clause 4 within brackets Roman of the OM date 29/7/2013 also provides that in case of any further application over and above 57 applications are subsequently detected in a district, the concerned deputy commissioner will carefully examine the authenticity of such application, and on being satisfied, place the same before the committee, district level committee, for taking similar action for appointment, as was done in respect of the other. Mr. UK Das, the council, placing reliance on clause 4 within brackets Roman 3. Clause 4 is also Roman 1B. Within bracket Roman 3 of the OM dated 29/7/2013 submits that as the petitioner has met her application on 7/11/2020, prior to the cutoff date of 22/6/2004. The petitioner would belong to the category of applicant whose application whose application can be will be should be considered in terms of the OM dated 29/7/2020, and therefore submit. DLC had included unit.
My lord, that is dear, my lord. Minutes of the meeting is page 53, my lord.
And as the district level committee had already recommended, district committee level committee, this is Nalbari,
My lord.
district level committee Nalbari, in its meeting held on 22/3/2017, had already recommended the case of the petitioner for appointment, a direction be issued to give appointment to the petitioner forthwith. Stop. He also assails the letter dated 28/12/2020, written by the Joint Secretary to the Government of Assam Elementary Education Department, to the Director of Elementary Education Assam, to wherein the department wherein it was stated that sanctioned vacant posts can be filled up only with the concurrence of Finance Department, then due procedure of selection to advertisement of the post, applications from eligible candidates may be received, and then among the candidates, competitive examination is to be conducted to find out the selected candidates to be appointed, and therefore the nomination for filling up of sanctioned vacant post was regretted. He submits that the said letter dated 28/12/2020 completely frustrates the aims and objectives of the rules of 1992 for which it was enacted. But Mr. J. Beku,
Yes, ma'am.
Learned Standing Council, Elementary Education, submits that what is your submission? You have not made any submission.
My lord, this letter was issued as per the Finance Department letter. You, my lord, annexer D, page our affidavit, my lord.
Annexure?
D.
That is
Last
employee
paragraph.
letter, my lord.
Submits that the impugned letter dated 28/12/2020 was issued as per the endorsements of the Finance SIU Department, conveyed by U number 568/2020 dated 16/12/2020. He therefore submits that as the endorsement has been made by the Department of Finance, the said letter was issued by the department. Para MS P.T. Burman, On the other hand, London government advocate appearing for the personal fee department, on the other hand, justifies the issue of the issuance of the memorandum dated 29/7/2013 issued by the
Principal Secretary.
Principal Secretary, the Governor of
Person will be different.
Mr. B. Gogoi, the understanding council final report. Submit on instruction. That the finance department on instruction that if authentic application with relevant records and the vacancy position are reported by the district level committee to proper can by the concerned deputy commissioner and government permissible age limit of the petitioner exceeds, the finance department will consider the case. That's all. Upon hearing the learned counsel for the part and on consideration of the OM dated 29 July 2013, which was issued after the repeal of the rules of 1996. This court is of the consideration that the case of the petition falls before the cutoff date of 22/6/2004, and therefore her case for consideration and therefore her case requires consideration under the rules of 1990. Where was that? Somewhere I've read that your age is 47. When you applied, it was 27.
That is my lord in minutes of the meeting, my lord. That is the man.
That was in page.
That is page 53, my lord. Right column, my lord.
The minutes of the district level commission, Nalbert, which held its meeting on 22/3/2017, recommended the case of the petition for appointment under the rules of 1990. While making the recommendation, it also observed that the applicant is that the petitioner is 43 years and 8 months as on 1/1/2017. But during the time of submission of application, i.e. 7/11/2000, her age was 27 years. 6. A perusal of the same would clearly indicate that the petitioner had met her application when she was only 27 years of age, and till date she has not been given. Therefore, direction is issued to the state respondent to condone the delay of condone the age of the petitioner for making appointment to the petitioner to a government court under the rules of 19. Further perusal of the report indicates that the petitioner had already approached this court in the year, where was that case number?
Page 40, my lord. 40. In Excel 5.
In the year
2002.
2003. While disposing of the said by filing WBC 9575 of 2000. While disposing of the said on 14/12/2004, this court has also taken into consideration the affidavit in opposition filed by the respondent that her case is still under trial. The process still continues. It is a clear case of such delay cannot be warranted by this court, especially when the petitioner is praying for an appointment to a government court in terms of the rules of 1992, which has been enacted by the state government under the proviso to Rule 309. Accordingly, the deputy commissioner will have to resubmit or what?
No, my lord. That is already in final stage, my lord. Proposal has already been sent to the government.
As the proposal of has already been sent by the deputy commissioner now. As early as when was the
last, my lord? Right, my lord, letter dated 19 October 2020. My lord, Director of Elementary Education, my lord, submitted entire, my lord, relevant papers, my lord.
Where is that?
Page 72, my lord. In XR 19.
As the Director Elementary Education has already submitted the proposal in format 1 and 2, Roman 2, for the year 2020-2021. Invest along with copies of post creation retention in connection with filling up of vacant posts of grade 4 regarding the appointment of petitioner under the rules of 1992 by letter dated 19th October 2022, addressed to the Commissioner and Secretary to the Government of Assam Education Department. The respondents are directed to expedite the matter and give appointment to the petitioner after verifying all relevant reports within a period of 3 months from the date of receipt of a copy of the with the opposite direction.
My lord, the impugn order may be set aside, my lord. Otherwise,
That is nothing much.
my lord,
It is a general order.
at least, my lord, one observation that this letter is not tenable in the eye of law.
Accordingly, somebody just
Page 75, my lord.
the impugned order letter dated 28 December 2020, written by the Joint Secretary to the Government of Assam Elementary Education Department and addressed to the Director of Elementary Education Assam is set aside.
Deeply applies.
11.
My lord, I think the government advocate has indicated that matters should be remanded to the director, my lord. My lord, it can be done. Only thing is, my lord, lordship will only point out which all are the aspects the director will look into, my lord. Actually, what had happened, my lord, for the same post, earlier there was a selection committee meeting.
In that selection committee meeting, I was given a particular mark. My lord, this time, this mark has not been given to me. For example, my lord, certain original documents are to be produced at the time that I have got the experience, that I have written so many research papers, that I have written so many articles. So what they normally do, my lord, at the time of interview, they physically check it. Now, this time, neither I was called, neither mark has been given. On 2 counts, my lord, I have been denied. Therefore, my lord, director, while looking into the matter, will also go into all these aspects. And till the director decides, my lord, your lordship's interim order will be enforced. That's my only thing, my lord.
No, let us see your facts.
Yes.
That means we'll go to the writ petition.
Yes. I'll rely on 2, my lord, the writ petition, and my lord, 1 affidavit in opposition, the reply. My lord, first the advertisement is page 28. No, second. Now, my lord, pursuant to this advertisement,
this is for appointment to
lecturer in ASMEs, my lord. Amongst others, 6, yes. My lord, pursuant to this advertisement, one lady candidate by name Vidisha Borgohai was purportedly selected. Then, my lord, there was some allegation that she was sought to be done a favor with. Then, my lord, the authority themselves, my lord, cancelled the resolution and issued a fresh advertisement. At that stage, I approached this honorable court, my lord, that if your lordship would kindly come to page 43, page 39, my lord, may kindly first come. Page 39, pursuant to the advertisement, first subpara, members verified all the original documents submitted in support of their candidature, and on the basis of the academic record, research contribution and experience, and interaction with the selection committee, Vidisha Borgohai was selected and recommended. Then, my lord, there was an inquiry which your lordship will get at page 40 and eventually at page 42. Page 42, 2. On the basis of the clarification made by so-and-so analysis company, the committee found that the above mentioned journal was not covered in the web of science journal till the date of interview. The committee therefore resolved to forward the inquiry committee's report to the GB, Silapathar College, for necessary action. Then, my lord, at page 43, the earlier recommendation was cancelled. After threadbare discussion, the governing body of Silapathar College in its meeting held on 3/12/20 unanimously resolved to cancel the recommendation of the selection committee for approval of appointment to the post of assistant professor in the Department of ASMEs in view held on so-and-so on the basis of the findings of the inquiry committee's report. Further, governing body authorized principal to re-advertise the said post. Then, my lord, at page 44, the re-advertisement was issued. Against that, we approached this honorable court, my lord, at page 45. Now, my lord will kindly come to page 47. Para 8. For the reasons above, we find the resolution number 4 dated 3/12/20 of the governing body of Silapathar College to be unsustainable in law. Accordingly, the same is set aside. The matter stands remanded back to the authority of the Silapathar College to bring the process of selection for the post of assistant professor ASMEs pursuant to advertisement dated 11/8/20 to its logical end.
That's the first.
Yes. Consequently, if there is any further re-advertisement, the same also stands set aside. So the this honorable court clearly directed, my lord, that the advertisement dated 11/8/2020 minus Vidisha Borgohai is to be brought to its logical end. Now, my lord, this time they have selected, they recommended this gentleman called Brojan Sharma, respondent number 4. Now, our case is, my lord, even Brojan Sharma does not have the required eligibility.
Where is that?
Yes. If your lordship would kindly come to para 8, my lord. Para 8 and 14, my lord. Para 8 and 14. That the petitioner, after appearing at page A7, that the petitioner, after appearing in the interview with all her research contribution and experience, came to learn that in the selection process, he has been awarded 66.54 marks. It is stated that as per serial number 25 of OM dated 8/11/18, 1 mark for each chapter article in the concerned subject published in the research textbook with ISBN subject to maximum of 2 marks is earmarked. The petitioner has reasons to believe that respondent number 4 has been awarded mark against serial number 2, 3, 2, 4, and 5 of the OM, though he is not entitled for the same. Similarly, aforesaid Srimati Vidisha Borgomai has also been awarded marked against serial so-and-so, though she is not entitled to. Then my lord will kindly come to paragraph 14, my lord. That the petitioner begs to state that in purported compliance of the order dated passed in WPC, the selection committee in its meeting dated 16/9/21, this is a subsequent one, had recommended respondent number 4 selection and appointment in the post of Assistant Professor in Department of Assamese, as pointed out herein above. During verification of document at the time of interview, petitioner had noticed the documents submitted by respondent number 4 in respect of serial number 2, 3, 4, and 5 are deficient and hence is not eligible. So, my lord, these are the aspects which in my humble submission, my lord director should look into. If your lordship should kindly take my reply in the IA, my lord. There I have given the details, my lord. There is an affidavit filed by the petitioner in the IA 244 of 22. There I'll have your lordship's kind attention to paragraph 8 and 9, where I have in details explained the position, my lord. It starts at, lordship may kindly come to page 4, para 8. Has lordship got? Yes. That while denying the statements made in para 5 and 6 of the interlocutory application, the petitioner begs to state that as there was no material available with the selection committee regarding Scopa's article of petitioner on 16/9/21, therefore it is not known to the petitioner as to how the selection committee in its meeting dated 16/9/21 had awarded 0 mark to the petitioner against the Scopa's journal. The same selection committee on 7/10/20, after verifying the original documents relating to Scopa's article, had awarded 4 marks to the petitioner. So this time, my lord, neither they asked nor they gave the mark. Because on 16/9, I was not intimated that there will be an interview. Based on the High Court order, they have done it still till the mind. This for the same Scopas, I was given 4 marks on 7/10/2020. Now this time they have not given. Then, my lord, another aspect is, please come to the subpara. In respect of ISBN publication, the petitioner is entitled to get 2 marks instead of 1 mark as the petitioner submitted 2 number of articles. The said fact is evident from the marks given to the petitioner by C. Biren Borua and Brajanath Borua. My lord, 2 members of the selection committee gave me 2 marks each for 2 articles, while other 3, my lord, they gave me only 1 mark each, including the principal, who is, my lord, for respondent number 4. So these are the, my lord, 2 aspects in my humble submission, director should look into. And my lord, they will call me, I'll come up with all the original documents. And as far as, my lord, respondent number 4 is concerned, please come to page 6, my lord. Subpara. In respect of respondent number 4, petitioner begs to state The relevant records will reveal that respondent number 4 did not support supporting material in respect of research paper article in the concerned subject domain published in so-and-so, clause so-and-so, and presentation of research paper in the concerned subject, etc. That is clause 2.6 of the OM. However, respondent 4 has been awarded total 4 marks against the aforesaid 2 clauses, although he is otherwise not entitled for those marks. Now, eventually, the sub-para, my lord, in view of the aforesaid facts, the marks allotted to respondent number 4 was it not in terms of OM dated so-and-so. As per record, total mark of respondent number 4 should be 68.4.63. That is 68.4.63 minus 4 because it doesn't have. As such, in the humble submission of the petitioner, the actual mark of the petitioner should be awarded is 65.68. In which case, my lord, I get the job. This is the point. So, my lord, let director look into it, my lord.
Who is this OM 811?
Kim, my lord.
OM 811.
Yes. Yes. OM is, my lord, page number 34. 2.
Which petition?
Yes, ma'am. And the operative portion is at page 34. To research contribution and experience, total 25 marks. Please come to Roman 3, 4, and 5. Research paper, article in concerned subject, domain published in journal, research book, etc. 1 mark for each publication in ISBN document published in UGC recognized journal. 4. Research paper article in the concerned subject domain published in impact factor journal existing in the database of Scopus, that is 4 marks, which I got, my lord, but it has not been given to me this time. Then 3, 5, and 6, it has been given to respondent number 4, which he is not entitled. Then 1 mark each for chapter article in concerned subject published in research textbook in ISBN subject to maximum of 2 marks. Then presentation of research paper in the concerned subject domain, 2 marks. 1 mark is for presentation of oral and 0.5 is for presentation in national regional workshop. In case of petitioner, my lord, 5 marks have not been given.
With regard to serial number?
Serial number 4 and 3. 3 and 4. And my lord, the respondent number 4 has been given 4 marks in respect of 3 and 6. Those he is not entitled to. 3 and 6. So, my lord, let director look into this aspect. And there is one more aspect, my lord. Director should also look into that. There is a circular issued by the government of Assam, my lord, which your lordships will get at page 55 of the writ petition, that if a particular government servant is holding a job or he has joined, then for within 3 years he cannot apply for any other government job. The idea is, my lord, because there is a lot of unemployment, therefore if somebody is already employed, because respondent number 4 is already working in a college in Karbi Anglong. After selection of any state government job with effect from 1st August 2016, employees are not allowed to employ any other state level government job in the same position up to a maximum period of 3 years. If unknowingly any state government employee do so, his candidature will be cancelled from both parts.
When did the respondent?
Yes, my lord, in this case, paragraph 18 of the writ petition we have stated, my lord. Para 18. That the petitioner begs to state that respondent number 4 has been appointed as assistant professor in the Department of Assamese at Government Model College Detour in the district of Karbi Anglong on 2012-2020 At present, the respondent number 4 is serving in the said place of posting. Petitioner begs to state that Government of Assam in Higher Education Department by OM had provided a ban for the state government employees who are selected with effect from 1/8/16 from applying to any other state level government job of the same position up to a maximum period of 3 years. In the said OM, it was further provided if unknowingly any state government employee has applied for a new job of the same position, his candidature will be cancelled from both parts. And these are the aspects. But therefore, my lordship may remand the matter. The only thing is, my lord, till the director decides, my lord, the interim order must continue.
Unless the director is decided, no appointment can be made. That is what this means. Because director is the appropriate approval authority who is to approve and decide. My lord, the case, my lord, what my learned senior friend has said. My lord, first of all, I'm coming to that 2018.
With the lordship's kind permission, my lord, in court number 1 happens. My junior friend will be there.
2016 notification will not come into play because when I applied, my lord, when the my lord, respondent number 4 applied, at that time he was not employed, my lord. It is apparent from the my lord statement of the my lord the petitioner itself. The petitioners have stated, my lord, the private respondent number 4 was appointed on 2012-2020 in Karbi Anglong Difu, my lord.
The director consider all this matter, Gogo.
Lordship, it's squarely covered by my lord judgment, lordship, in WPC number lordship 511-22. Akram Chandrajit Sinha, lordship has already decided that particular issue, lordship. It is squarely covered case. My lord may remand back the matter. The petitioner file a representation before the authority, lordship, ventilating all the grievances, lordship, and the director will consider. And lordship's judgment also same line, lordship.
Yeah, I think instead of giving a direction,
Lordship.
My lord.
to the director to consider this part, this
Lordship.
part, this part. I think
Lordship.
it will be better if I give you an option.
Lordship, earlier
Make a
judgment.
representation,
My lord, my lord.
getting all your ground,
Yes, my lord.
as well as this one number
Siman to
4.
decide.
Yes, ma'am.
Decide.
Then
Nara.
decide the matter. Instead of this court.
Yes, my lord.
Did you?
We will file a detailed representation before the director, my lord.
stating all your-
Before taking any
Siman,
decision, my lord, we may kindly be heard, my lord. If director rejects.
Yes,
Yes, ma'am. I am obliged.
in
ma'am.
a personal hearing.
Yes, ma'am. I am obliged, ma'am.
If requires personal hearing may be done.
Buying is for.
I am for the college, my lord, college authority.
Okay,
Principal.
College authority.
Yes.
And,
I am for question number 4.
Just a minute. Let Mr. Ken Jody, then a senior counsel. Assisted by Mr. I am the.
My lord.
Then a counsel for the petitioner. Also heard Mr. K. Gogoi, standing counsel, higher education. Correspondence 1 and 2. Mr. G. Bayan.
Yes.
For the response number 3.
Three.
And Mr.
SN Krishna Traya. SN Krishna Traya.
For the response number 4. The who issued this advertisement? The principal. Silpata College. Silpata.
Sila.
Just correct me when I'm wrong.
My lord.
Yes.
No. Issued an advertisement calling for application to fill up. The post of assistant professor. Assistant professor.
Yes, my lord.
Yes.
Assistant professor. In different departments, including Assamese department. The petitioner and the respondent number 2.
4, my.
4, being eligible. They applied for the post of assistant professor in terms of the second. Thereafter, the Selection Committee in its meeting held on 7th October 2020 for selection of candidates for the post of Assistant Professor in the Department of Assam, within bracket UR, recommended the case of one Bitisha Boragohan.
Yes.
For the said post. So, however, a dispute arose with regard to one of her journals, and accordingly, an inquiry committee was constituted by the governing body of Silapatha College, and the inquiry committee, by its report dated 7/11/2020, came to the conclusion that the disputed journal
Yes, Philip.
of the said Srimati Bitisha Boragohan was not covered in the web of the Science Journal till the date of interview, i.e. 7/10/2020. So, but in terms of the report of the inquiry committee, the governing body of Silapatha College, Silapatha, resolved to cancel the recommendation of the said president and authorize the principal to re-advertise the said post with immediate. Accordingly, the principal, Silapatha College, Silapatha, re-advertised the post of Assistant Professor Assamese, within bracket UR, on 5/12/2020. Being aggrieved, new para, huh? Being aggrieved with the advertisement dated 5/12/2020, petitioner approached this court by filing WBC 5663 of 2020, which was disposed of by order dated 8/4/2021, with the following observations and direct. Page 47, 8 to 8. So, para. Consequent to the order dated 8/4/2021, passed by this court in WBC number 5663 of 2020, comma, the selection committee
Yes, ma'am. Selection committee of the college, ma'am.
of the college recommended the case of the respond number 4 for appointment to the post of Assamese assistant professor, Assamese department within bracket UR. So, being agreed with the recommendation of the respond number 4, petitioners before this court, challenging the recommendation of the respond number 4 on the ground that the where was that office memorandum, which on the ground that the selection procedure for the post of assistant professor bracket Assamese UR is vitiated in as much as the guidelines for selection of assistant professor oblique librarian in Provincialized colleges of Assam, given by the office memorandum dated 8 November 2018, issued by the Higher Education Department, Government of Assam, has been violated, particularly with reference to not required has been violated.
Yes, ma'am.
Another ground taken by the petitioner is that the office memorandum dated 25th June 2016, issued by the Commissioner and Secretary to the Government of Assam Higher Education Department, is also violated by the response number 4, which provides that after selection of any state government job with effect from 1st August 2016, employees are not allowed to apply any other state level government job in same position up to maximum period of 3 years. So, if unknowingly any state government employee do so, his candidature will be cancelled from post. It is the case of the petition that the respondent number 4 has been appointed as assistant professor in the Department of Assam at Government Model College, Cutoff, in the district of Karbi Anglong on 2012-2020. As such, respondent number 4 is debarred from applying for the post of assistant professor Assam in what college was that?
Silabata College, ma'am.
In Silabata College, Silabata, in view of the office memorandum dated 25th June 2000. But after perusal of the materials available on the report, it appears that the director, elementary,
Higher education, ma'am.
higher education, is yet to take a final decision in the matter. And therefore, this court is not inclined to is not inclined to entertain this petition at this stage. So, but however, petitioner is directed to file a detailed representation, taking all the grounds, by enclosing. You want to enclose a copy of the writ petition?
Yes, ma'am. We can enclose it,
By
ma'am.
enclosing a copy of the writ of this writ,
As well as the
Along
agreeing
with-
opposition, ma'am.
along with the annexure form, the affidavit in opposition
File in the IM.
filed by the petitioner in IA number
IA number, my lord, 2044 of 2022.
2024, before the Director of Higher Education, Assam, within a period of
10 days, my lord, from today.
within a period of 2 weeks. from today. You want to file a representation also? Respondent before?
If,
No. On receipt of the representation, the Director of Higher Education Assam shall hear the petitioner in person, as well as the respond number 4, and thereafter pass final order for appointment of assistant professor within brackets Assamese within brackets you are in Silabata College, Silabata, by
Lordship, respondent as well as respondent 3 also, Lordship. College authority have to, Lordship.
as well as the respond number 3.
3 and 4, Lordship.
Respondent 3 and 4. Respond number, just say, shall hear the petitioner in person, along with the respond number 4, i.e. the principal Silapatra College, and the respondent number 4, Dr. Brojin Sharma. And draft the past final orders for appointment of Assamese in Silapatra College, Silapatra. Where's the office? You want this to be taken into consideration? Office memorandum.
Yes, my lord. Yes, my lord.
By taking into consideration the office memorandum dated 8 November 2018,
And
as well as the
25.
office memorandum dated 25 June 2016. And thereafter pass appropriate orders according to law within a period of 4 weeks. 4 weeks from the date of the representation. Till the representation is considered and disposed. And final orders are passed. Interim order passed by the court shall continue.
No,
My lord,
I am obliged, my lord.
One fact, my lord, 2016 notification will not come into play.
That I'm not saying anything. Just a director consider, and then apart from that, you will be heard together with
Yes, my lord. I am obliged.
the IA in view of the order.
I may also be disposed.
17 and 18.
Lordship, in item 17, I am the petitioner, my lord, and item 18, I am respondent number 6. In item 18, my lord, my case is that I was appointed in the year 1995. I joined my service 1/11/1995, and respondent number 6, who is the petitioner in item number 18. He joined as assistant teacher in said school 15 to 1996. So I am the senior.
You joined on?
I joined on 1/11/1995.
Petitioner?
I am the petitioner in item 17, and respondent number 6 joined on 15 to 1996. I am language teacher. He was initially appointed as science teacher. Subsequently, another science teacher was appointed. So my case is that, my lord, I am the senior. As a language, I am senior, but his name has been recommended. Page 27, my lord. Page 28, my lord. 28, 28. That is the recommendation of District Scrutiny Committee. Rajiv Lotion, my lord, in middle. That is the respondent number 6 in my petition. He has been recommended as language teacher. Right column, my lord. Lordship. Then below, my lord, my name, Pradeep Kumar Roy, ASM language teacher. But I have been considered as language also, but not recommended. His name is recommended as language teacher. Thereafter, page 20, page 32, by website list, his service has been provincialized as language teacher, depriving me, my lord.
By the SLC.
By the government, SLC also and government also, already provincialized. Now my friend filed the item 18, saying that no, he is claiming that now he is a science teacher. So his service should be provincialized as science teacher in place of language teacher. So definitely there is no case, he has no case against me. So I am the language teacher. He is now claiming he is the science teacher. He is arrayed another respondent number 7, who was appointed as science teacher. Now fight is between respondent of respondent number 6 of my petition and respondent number 7 of item number 18. So he is not claiming now he is the language teacher. So he is now claiming he is the science teacher. So his service should be provincialized as science teacher instead of language teacher. So item 17, my prayer before you, Lordship, since I am the language teacher and I have been different, so maybe disposed of with a direction to provincialize my service as language teacher, setting aside his appointment, my lord, as language teacher. And item 18 may be referred under under section 14. If he is, because he is now not claiming that he is a language teacher, he is claiming that he is science teacher.
May I please, as your lordship? My lord, in fact, my respected friend submission, my lord, what has happened, my lord, initially, my lord, when the recommendation was there, I was recommended as a, my lord, language teacher, and my service has also been provincialized as a language. Now, my lord, this honorable court, by way of an interim order, is directed not to give effect to my provincialization as a, my lord, language teacher. In fact, my lord, from the date of appointment and till date, my lord, it is an admitted position that I am teaching the science subject and I am a science teacher, my lord. But what has happened, my lord, in my petition, the private respondent has been given the benefit of science and I was given the benefit of a language teacher. And as a result, my lord, my friend was dropped and could not be considered for the purpose of provincialization. Now, my lord, as my lordship has taken a view, my lord, in the various cases, that in such type of disputes, my lord, the appellate provision is there. And my learned friend has already preferred an appeal. In my lord, in his petition, my lord may be pleased to find the appeal. Is that page, my lord, 42, my lord. And this appeal has not yet been considered till date. So, my lord, in his case, this petition can be disposed of by directing the, my lord, the Director of Elementary Education in the capacity of section 14. My lord, he can take into account this appeal and can pass a reason order, my lord. And in my petition also, my lord, the similar my lord, directions can be issued by directing the authorities. I mean, appeal. And we can also prefer an appeal, my lord, before the authorities, and authority can dispose of, my lord. And in that line, my lord, if my lordship is satisfied, my lord, then both the petition can be disposed of.
My lord, since item in my case, my friend has no grievance. He has already filed item 18, my lord, claiming that his
Grievance is not there, my lord, but the issue is that his provincialization is required to be done by the due procedure of law, my lord. Now, that the director cannot take up that suddenly issue an provincialization order, as I do not have any claim.
provisions of law,
My lord, the issue is required to be come up from the proposal from the district scrutiny committee, my lord. As there was no proposal from the district scrutiny committee for the purpose of his provincialization as a, my lord, a language teacher. So it is required to be done at the level of the district scrutiny committee, my lord. So that process they will take up in the appeal, my lord.
What, Mr.
MR Khandoga.
Also heard MS
And
and Fukan, then standing council,
element.
elementary education, correspondence,
1, 2,
1, 1 and 1, 2,
4,
4,
1 to 4, my lord.
4,
And
5,
5, my
5,
lord.
and 1, 2, 4, 5.
my lord.
MSD department and government correspond number 6. And you are
My lord, I am for the respondent number
we
6
are
in my
the
friend's,
respond number
my lord.
top. The case of the petitioner in the present is that he was appointed as
At headmaster, but teaching language subject.
headmaster of Pachim Deputar Madrasa M School and teaching the subject of
Language.
language. Stop. So he was appointed as headmaster on 1/11/1997 in Pachim Center, teaching the language. The private respondent was appointed as
assistant teacher science
assistant teacher within bracket science on 15 to 1996 in the same school. So when the process of provincialization for the teaching and not teaching staff of the Pachim Diputar at Asta school was taken up in terms of the of 2000. The state level district level committee recommended the case of the response number 6, where the district level
page 28, my lord.
case of the response number 6 as a language teacher, and the case of the petitioner was not recommended. For being aggrieved, petitioner draft the response number 6 was provincialized
The language.
as a language teacher by
Not by the
By order dated
order dated 5/2/2021.
5/2/2021. So, for being aggrieved, petitioner made
Both sides benefit.
filed an appeal under
I will file a fresh, my lord, if required. It will be better, my lord.
filed an appeal under section 14 of the Act of 2017 before the Director of Elementary Education. So, at this stage, Mr. M.R. Kantahar, learned counsel for the that the petitioner may be permitted to file a fresh appeal under section 14 of the Act of 2000. But recording the submission of the learned counsel, the state petition is disposed of, directing the petitioner to file a fresh appeal under section 14 of the Act of 2000 before the state scrutiny committee. State level
Scrutiny
before
Committee.
the state level scrutiny committee. Within a period of
15 days.
120 from today. Draft report on receipt of the representation, on receipt of the appeal, the state level scrutiny committee shall consider the appeal after giving an opportunity of hearing to the petitioner as well as the response number 6 in first, and thereafter pass appropriate order in accordance with the within a period of 2 months. 2 months from the date of the appeal with the
Interim order may be vacated, my lord.
No, my lord, since his provincialization is not now different angle is.
No,
taking.
interim order is already.
The thing is, you are also not asking for science teacher, isn't it? You are now asking for science teacher,
Yes, my
Milord,
lord,
Milord.
not as a linguist.
not
No,
like
no,
this.
Milord, at this moment, Milord, my provincialization was done as a language teacher by way of a due process of law. Now, if the authorities, after hearing the appeal, Milord, find that the yes, my provincialization is wrong as a language, then that will go, Milord. Till date, as my lordship has not set aside. So therefore, the interim order cannot.
No, my
hold,
lord,
Milord.
that may not be justified. my lord.
Mile, highly
Now,
obliged.
what is in your writ petition?
In my petition, Milord, I am challenging the provincialization of my respected
No,
senior
Milord.
friend, Milord.
Milord,
Oh.
since Lordship Milord,
Oh.
consider item number 17, being him as the Milord language teacher. So in the same time, he cannot claim for
Cannot claim science teacher, my lord. He is claiming double, my lord.
First, Milord, the
When the petition is disposed of, at that time,
He claims science, now claiming benefit of language.
Because
My lord, how is
there is no dual service rule,
No, no, my lord, I am not claiming the double benefit, my lord, which I even cannot. Only the issue is, my lord, that as I am a science teacher from the date of my birth, when I was appointed, my lord, and now, my lord, the authorities has wrongly provincialized me as a, my lord, language teacher by way of a provincialization order. Till date, my lord, that provincialization order is holding the field as it has not been set aside. Now, my lord, in the meantime, if I do not claim that my service should be provincialized as a science teacher, my lord, then there will be, my lord, another complication that I may waive my right. So that's why, my lord, the second writ petition I have filed that the provincialization of my respected senior friend as a science teacher is not correct. It should be me. So, my lord, that issue can also be looked into by the director, my lord. What is the difficulties, my lord? I am not saying that his provincialization should be set aside, my lord.
You have already been provincialized, isn't it?
No, that is correct, my lord. If in the appeal filed by in the earlier writ petition, my lord, if my provincialization is set aside, my lord,
one thing, my
as
lord.
a
My friend has filed for vacating
Right.
stay order, subsequently withdrawn, my lord. Stay vacating of stay order. When he is claiming science, your lordship has asked whether you are claiming science or language. Then he has withdrawn the order, my lord.
Yes,
I am, my lord.
Mr. Bhuyan.
How is it, my lord?
my lord.
He
My lord.
is going two ways, my lord.
No, I am
One
my
way
lord,
claiming he is provincialization is language, other way is claiming science, my
my
lord.
lord, my
On that day, I has been
then,
withdrawn.
my lord, I am allowed to withdraw my second petition, my lord, and with the liberty to file a fresh if, my lord, situation arises, my lord.
Mr.
Air Bhuyan, my lord.
Air Bhuyan, let us talk about in the second phrase for withdrawal of this.
I might have, yes, resolution number 7 million in item of
You go to the file after.
DAKU million. Resolution number
1
7.
My lord,
who appears for the elementary MS N Pukan and turning council elementary education appears for respondent. 1, 2,
1, 2, 3,
5,
4, 5,
1, 2, 4, and 5.
5.
5.
4 and 5.
1, 4, and 5.
And
I am for 6.
VAKU million for resolution number 7.
VA
VAKU.
council appears for respondent.
I am for 6, my lord. I am a control.
My lord, liberty may be given, my lord. Otherwise,
Is accordingly dismissed from withdrawal with liberty as well.
My lord, one thing is there, my lord.
oblige.
After appointment of respondent number science as science 7 as science teacher,
You
my
will
lord.
be all hurt together.
My lord,
I am,
highly obliged.
my lord, interim order will remain, my lord, till decision.
No, it has been vacated. 19.
Please, Your Lordship.
My lord,
The
that will be, my lord,
petitioners constitute.
for the time being, my lord. Mr. K. Gogoi is held up in court number 12, my lord.
In any
Timing,
case, we have got
timing.
just 5 minutes. I can complete my part. Then he can take over after that. The facts I can please, probably.
So we'll resume at 2 then.
Not sure.
Much apology.
Chaudhary. HRA Chaudhary.
My lord, yes, my lord, he is junior, my lord.
This matter after 1 week.
$21.
None appears for the case. It's the matter of the
22. Item number 22 also lordship, no penalty was attained lordship. Lordship has already decided that my one matter today lordship, item number 11 lordship.
No, Lordship, if it is the question, Lordship, I can show that the director Melafadli, Lordship, the candidate has forwarded his name for appointment. However, I got that information and I stopped.
See, I have the records lordship.
That is
I
the
have the-
author of a
I
sign
have
as
the
stated.
records lordship, no penalty was attained.
Then judicial inquiry may be given, how can this come? Already appointed.
No appointment was done lordship, this is the record. This is the record. We have sought clarification from the university's authorities lordship. They have clarified whether the recommended candidate will entitle the marks or not lordship. After that stage lordship, no appointment was done lordship. Appointment দিয়া নাই তেওঁলোকে। নাই দিয়া।
One small submission before Lordship I have made.
Serial number 542, Lordship.
Lordship, this particular list was lordship published as a whole in Assam lordship regarding whose appointment will be considered. That particular college, no appointment was done lordship. This is the record lordship, no penalty was attained lordship.
This is done because, Lordship, I have submitted application that day, Lordship. Otherwise, that approval has been done, Lordship. That when I see this notification in website, immediately I ask the court by order. There's an interim order. I have submission. Then without approval, how did this stand, Lordship? Lordship, that is the malafide intention. So, Lordship have to.
Whether it's a malafide or lordship, intentional intention, it should be decided by the directorate lordship as per my lord's direction lordship. The original record is before my lord. My lord
Yes.
can peruse lordship. No decision was taken till today lordship.
And Lordship may take it.
This is the original record, selection records lordship. This is the original selection record lordship. No decision was taken lordship. Because of the interim order passed by this honorable court lordship. The authority of director lordship, after receiving the complaint from the petitioner side lordship, sought clarification from the concerned university authority whether that marks the candidate will entitle the marks or not lordship. Then the university clarified that lordship, that particular journal was lordship in the website up to 20 lordship. That is the last stage of the selection process lordship.
Till now, no decision has been taken.
No decision.
No decision was taken.
According to him, no decision. But Lordship, kindly see this.
No decision was taken lordship.
Yes, I've seen.
Lordship, serial number 542, Lordship.
Serial number?
542. Naga College, Naga Dr. Manas.
This was not done lordship
Lordship.
because honorable court's direction is there lordship.
Then I, Lordship, oppose the director and I have filed objection, Lordship, because you don't, because there is a stay order. Then, Lordship, it was stayed. Now my prayer is, Lordship, at this stage, Lordship, if Lordship send back to the director, then director will take same decision, Lordship. Yes, Lordship, my simple prayer is that Lordship kindly fix the matter in a date and let the director file affidavit that I am entitled for this mark or not, because there is an office memorandum clearly shows that she is not entitled for the marks. The office memorandum can file us, then Lordship, I have nothing, Lordship. Lordship, kindly.
All these things are covered by my lord judgment. Today, my lord delivered the order 11.
19/9/2022.
Item number 11, lordship. Item number 11 also same issue was raised before by the petitioner lordship
Yes,
regarding
Lordship.
not giving of the particular marks. Then my lord remanded back the matter to the authority today.
I have-
Lordship, today,
I have-
lordship.
I have objection, but if reminded, Lordship, that approval will be done. Lordship have to
In
give-
matter, lordship cannot enter.
No, Lordship.
This is my last submission, lordship. As per
Yeah,
various
Lordship.
orders of the
Decision has been
honorable
taken,
court.
counsel.
lordship.
No decision has been taken.
Not again. So the decision, Lordship,
But
then,
what is this order? That-
yes,
There's already a decision.
yes, Lordship, how can this?
That was lordship on that is not a final decision. That was a list prepared by the directorate lordship on the basis of the recommendation given by the college authority lordship. After that list was published, lordship, anybody can complain also lordship.
No,
And that
Lordship, there is
if-
other
if
candidate have
Lordship,
already
that
appointed.
even a decision or appointment was done, Lordship, then file, my lord may kindly peruse the file, Lordship.
So have you got a copy of this?
I have no Lordship.
Hmm.
This was published, Lordship, after the honorable one writ petition was filed before this honorable court, challenging the whole recruitment process regarding that particular OM. After that, honorable court directed us to go ahead, Lordship. Then the list was published by the authority in the website, Lordship. These are the candidates whose names were recommended by the authority. But in this case, Lordship, the recommendation by the authority was not yet finalized, Lordship. Because there is honorable court's direction is there, no appointment should be made.
Gogoi, one
Lordship.
thing which I don't understand
Lordship.
is that I have the honor to inform you, Government of Assam Higher Education is pleased to issue appointment letter.
Yes, Lord.
Lordship,
Yes.
that was not done in respect of in this particular college, Lordship. Kindly peruse that file, Lordship.
No, I've perused the file. I'm not
Lordship.
finding anything.
That was not done, Lordship.
You give me the relevant page,
The note sheet reflect, Lordship. Note sheet reflect, Lordship.
not check.
Note sheet, Lordship.
Then
Note
where is
sheet
my
reflect last note sheet, Lordship, my lord may file, kindly peruse last note sheet.
Then Lordship, where is my objection letter? That day I filed that you don't give appointment because there is a stay order.
Otherwise,
Yes,
Lordship
sir.
may decide the matter also, then respondent will get the marks, Lordship. I will place it as
Who
per
will
the,
get? Lordship will, I am ready for argument. Lordship.
and it will be, Lordship, amount to Lordship dilute the my lord's order.
No decision has been taken
Lordship.
as per this report.
Yes, yes, Lordship. So I don't. Lordship,
In
my-
this case, I also appear for responder 3 and 4, my lord, selection committee and the principal, my lord. In fact, my lord, without reaching the finality of the decision-making process, he has approached this honorable court. Only on that issue, my lord, this petition is liable to be dismissed because the decision-making process has to be reached, my lord. Then only interference of this honorable court will come, if anything wrong, my lord. And here is a case, my lord. The college is in dire necessity of a teacher, my lord. And
But when-
because of the interim order, my lord,
Yes,
When no
that is-
decision is taken, where is your locus?
yes, Lordship, kindly see page
Where is
number
your
20.
course of action?
Yes, yes, Lordship, kindly see page number 27, then Lordship.
Which-
My petition, Lordship. Page number 27, Lordship.
all these things will be
Lordship,
seen by
Lordship,
the
Lordship, kindly see page number 27.
Hmm.
I have filed this petition 20, Lordship, 2020, file of action. Has any direction? Is
Then let the director consider your representation when he's
yes,
finalizing the matter.
yes.
yes, Lordship, then Lordship will kindly apprise me, Lordship, Lordship, in this case, Lordship, my whole petition is that Lordship have to observe it. I have no problem. Lordship can demand, but reasonable opportunity may be given to me also, Lordship, because Lordship kindly say
Yeah,
Yeah.
take note.
there is a office madam because
Mr.
D. Mohanta, Lordship.
D. Mohandal, let the council. And where's the advertisement?
Lordship, advertisement dated 12/8/2020.
Where is that?
20, Lordship.
Where's that advertisement?
Advertisement can Lordship, annexer, Lordship, annexer 1, Lordship. Page number 22, Lordship.
You applied for which post?
For Assistant Professor Philosophy, Lordship. In the Department of Philosophy, Lordship. Naga College.
Both the private respondent and yourself.
Lordship.
Pursuant to an advertisement. Oh, sorry, thank you. I heard Mr. D. Mohandal. Also heard Mr.
Yeah.
Over is appearing.
Yes. I am appearing for 3 and 4, my lord.
1 minute, 1 minute. Mr. T. Gogoi, learned standing counsel,
1 and 2, Lordship.
higher education for respondents 1 and 2. Mr. B. Chowdhury,
B. Goswami.
B. Goswami, learned counsel for respondents 3 and 4.
I pay for the private respondent, the selected candidate, rational number 5.
M. K. Chowdhury, learned senior counsel, assisted by Mr. M. S.
And dot.
And the
And
and
dot.
Dutta for respond number 5. I'm remanding it back to the director.
In fact, my lord, this is a premature
That's
case.
why I'm saying. Let the director take a decision.
Yes.
Lordship, I pay for Lordship, one part matter is going on, Lordship, may I leave, Lordship?
Pursuant to an advertisement issued by the principal, Naugong Girls College, Naugong, Assam, calling for application for filling of various posts of assistant professor in different departments in the Naugong Girls College. The petitioner and respondent number 5 both applied for the post of assistant professor, philosophy. Within PWD? No,
No, that's general category.
philosophy, you are. The selection committee recommended the case of the respondent number 5 for appointment to the post of assistant professor. In the present petition, the issue raised is that 5 marks were incorrectly given to the respondent number 5
That's
in the selection process for the post of assistant professor in philosophy in the Naugong Girls College. However, on a perusal of the record, it appears that the director higher education is yet to take a final decision. The records also reveals that the petitioner has made representation before the director of higher education on 21/11/2020, bringing out the anomalies made in the market made in awarding mark in the selection process of assistant professor in philosophy of Naugong Girls College, Naugong. As a final decision is yet to be taken by the director higher education till date, I am unable to entertain this in as much as I am of the consider of case that the present writ petition has been filed merely on application. Accordingly, writ petition is dismissed. However, as the petitioner has already made a representation before the direct higher education Assam on 21/11/2020, the director higher education of response number 2 is directed to consider it while making a final decision with regard to the selection of the assistant professor for the post of assistant professor philosophy in Naugong Girls College. It is also made clear that the petitioner that the respondent number 2 shall hear the petitioner as well as respondent number 5 in person and draft past final law. Let draft the past final law. So let such step be taken and completed within a period of 4 weeks from the date of the copy of the order.
Lordship, before giving appointment, Lordship, final order have to be communicated both of the petitioner 10 days ago. Otherwise, Lordship, today, if suppose he has taken some decision, I cannot file to 10 days. If both the parties, I am agree, if Lordship,
The
10 days
final decision of the Response number 2 shall be communicated both to the petitioner as well as. You can check with the report.
Appellate.
Lordship, I beg apology. In item 21, your lordship, I missed.
I've already passed out.
There is some urgency, date may be 15th.
What did I say? Item 61? Third, Mr.
MH lordship.
MS Russell, let us call. Is the matter again on?
16th of next Thursday, your lordship. There is some urgency in the matter. If
13th March.
then let it be on 15th, your lordship. I may not.
15th of.
Oblige.
Item is this. Yes, who have it? You have it?
My lord, 13 and 54 was supposed to be taken up together, and I was led by Mr. UK Nayak. He's in another court. So
Advocate General is here.
yes, that is the reason. my
I
lord.
came in the morning also. Anyway, lordship.
My lord, then I'll do the case.
If you are ready to.
Yes,
take up,
ma'am.
I'm ready. Otherwise, if you want an adjournment, I can adjourn.
No, wait, tomorrow is the last day of the filing of the application. My lord, I have prepared a small short notes, my lord. Give me a- Or at a photo. My lord, would your lordship be pleased to take up the 54 item, my lord?
I want. Item 54.
Yeah.
It was 13. What matter is this?
My lord, this matters, your lordship, on last Friday, your lordship heard the matter, and because of the AG's presence was required, that is fixed today, my lord. This is in respect of advertisement issued for, we have cited 4 advertisements which was issued for recruitment to the post of graduate teachers and postgraduate teachers in respect of provincialized high school, higher secondary school, and government high school and high secondary school.
Who are the advertisements?
Yes, my lord. My lord, the advertisements are annexure 1 to annexure 4. It starts from page 28.
First, next two.
My lord got page 28.
Yes.
My lord, this is the second line, my lord. 1385 vacancies of postgraduate teachers in different provincialized secondary schools.
Yes.
My lord, the second one is page 32, my lord.
Annexure 1 is how many posts?
My lord, 1385, 1385.
Yes.
For PGT, my lord, postgraduate.
Hmm.
And that is also in provincialized as secondary schools. My lord, next annexure 2, page 32.
Hmm.
My lord, this is against for postgraduate teachers, 118 vacancies in respect of government secondary schools. Government secondary schools and the provincialized secondary schools are governed by 2 different set of rules. One is 2018, one is 2020. Annexure 3, my lord, page 38.
Yes.
7,500 vacant posts. That is for GT, graduate teachers, in respect of provincialized secondary schools, my lord. And my lord, annexure 4 is page 45. Page 45, my lord, got it.
Yes.
My lord, second line, 255 vacant posts in government secondary schools, that is in respect of graduate teachers. My lord, I'd like to draw my lordship attention that a small note I prepared. I've given to them.
The note that you just.
Yes.
Yes.
My lord, the first page is in respect of graduate teachers. My lord, 14/8/2019, DSC Assam issued an advertisement for the graduate teachers and postgraduate teachers in provincialized high and high secondary schools. 29/8/2019, this honorable court was pleased to give a direction to hold TET first and then go with the recruitment process as per 14/8/2019. Then, my lord, Honorable High Court's order was followed, and on serial number 4, on 13/11/2019, this date is, my lord, important. 13/11/2019, DSC Assam issued advertisement for conducting TET in respect of graduate teachers in provincialized high school, high secondary school. My lord, on 19/9/2020, TET was conducted for graduate teachers.
19/1 or 19/9?
19/1/2020,
Yes.
serial number 5. My lord, got it.
Yes.
My lord, TET conducted for graduate teachers, and it is about 35,814 appeared. And the results were in 3 phases, and ultimately total pass was 12,032. The posts released in respect of graduate teachers for those TET appeared candidates, my lord, total released from 5/8/2020 to 31/12/2021, 13,905 posts. So your lordship may see one thing, the total passed was 12,032, post release were 13,905. My lord, I have added that 128 more posts released for GT, which is not part of the WPC. We came to know later on, my lord, this advertisement 31/2023 by Adarsha Vidyalaya Sangathan, they over there 107 posts of GT, that is under the secondary education. And another advertisement was issued only on 25th of this month. That is, my lord, advertisement number supposed dated 25/2/2023, 128 posts. So if we take this total post released, it comes to about 14,033. My lord, if your lordship looks at the serial number 4, the date 13/11/2019, when the advertisement for conducting TET in respect of graduate teachers was issued, taking that date, my lord, last line your lordship would say, your lordship would see no TET for graduate teachers in 2020 to 21 and 22. In respect of graduate teachers, no TET has been held for last 3 years. Now, my lord, next page is for in respect of graduate teachers, postgraduate teachers, PGT. My lord, serial number 2 is the same recruitment process which was challenged in this before this honorable court, as I cited above. And ultimately, this honorable court issued the direction to hold the TET and then only go with the recruitment process. This judgment was followed. And serial number 4, 18/11/2020, DSC Assam issued advertisement for conducting TET in respect of postgraduate teachers in provincialized high secondary schools. On 10/1/2021, TET conducted for postgraduate teachers, 21,256 candidates appeared. Results were issued in 2 phases. Ultimately, 2,893 passed, and post released for the graduate teachers was in 3 phases. Total post release was 2,584. Is
is about 300 less than the total candidate passed. My lord, the present case is 28/12/2022 4 advertisement for recruitment of graduate teachers and postgraduate teachers in provincialized government secondary and higher secondary schools have been published. Graduate teachers in provincialized secondary schools 7,500. Graduate teachers in government secondary / high schools 255. That comes to about 7,755. This is my writ petition. Otherwise, there is another 128, which is not part of the writ petition I mentioned earlier. And for postgraduate teachers, my lord, it comes to 1,385 and 118. It comes to 1,503. On 14/2/2023, notice for submission of application fixed from 16 to 28. That is tomorrow, my lord. 20 is the deadline. My lord, as per NCT, TET is compulsory for elementary education, but our state government has inserted that clause in the secondary education. And what I believe, my lord, if they have inserted the requirement of TET is required for recruitment to the post of graduate teachers and postgraduate teachers, then they should hold the TET examination every year as it is mandatory in respect of the elementary education, my lord. And for post-graduation teachers, my lord, if your lordship looks at the serial number 4, 18/11/2020, that is in the second page. 18/11/2020. My lord got it.
Yes.
This is the date when the advertisement was issued for conducting TET. If we take that date, then my lord, no TET for PGT in 2021-2022, 2 teachers for 2 years. So for graduate teachers, it is for last 3 years, and for postgraduate teachers, last 2 years. My lord, this issue did crop up in the year 2019 before this honorable court. And this honorable court at that point of time decided that recruitment process which was tried to be initiated, that should be halted and the TET should be completed, and after passing and after the declaration of the result, then only the recruitment process should carry out. My lord, while deciding the matter by the learned single judge in that case, there was a writ appeal in respect of elementary education. The ratio was applied in this case. If I draw my lordship's attention to page, my lord, it starts from page 54, annexure 8. And relevant portion, my lord, is page 73, para 8, 9, and 10. Page 73.
Yeah.
May I read it, my lord? Paragraph 8, my lord. This is after taking the various paragraphs of the writ appeal. Para 8. Normally, this court cannot issue any direction to the state authorities to relax any essential qualification, as it would be within the wisdom of the employer to do so. And in the present case, the state government is the competent authority to relax any such essential qualification, and as such, under normal circumstances, it would be difficult for this court to issue any such direction to the state government to allow the petitioners to take part in the recruitment process without having that qualification. 9. However, the petitioners have raised a very fundamental issue that since the state government did not conduct any TET examination since 2013, in that case, it was still since 2013. And as such, the petitioners could not obviously appear in the TET and resultantly could not obtain the TET qualification. Insisting on possession of such qualification by the state government is unreasonable. This court is also of the opinion that under such circumstances, if the state government is insisting on a condition which is impossible for the petitioner to comply with, such insistence on the part of the state government of the candidates to possess TET qualification will be violative of the equal opportunity assured under Article 16 of the Constitution of India, which provides that there shall be equality of opportunity for all citizens in a matter relating to employment or appointment to any office under the state. Therefore,
In the present case, by insisting upon a qualification which the petitioners had been deprived of not acquiring by not holding the TET examination by the state government since so and so, the petitioners have been put to a disadvantaged position. Thus, the petitioners have been virtually discriminated as far as the opportunity to compete for the aforesaid post is concerned. Paragraph 10. This court is also of the view that even though the aforesaid decision in WA number so and so was passed with reference to the recruitment in elementary education department, the same principle can be applied in the present case also relating to the appointment of graduate and postgraduate teachers in high schools and high secondary schools. And my lord, finality was in paragraph 11. Accordingly, considering the submissions advanced by the learned counsel for the parties and the decision rendered by the division bench of this court in WA number so and so on so and so, and for the reasons discussed above, this court is of the opinion that the present petition can be disposed of with a similar direction. Accordingly, this petition is disposed of with the following directions. 1. The state government will immediately take steps for holding the TET examination so that the petitioners or such other candidates who may be desirous of obtaining TET qualification may appear in the same. Second, it is only after the TET examination is held and results thereof are declared that the state authorities can proceed with the recruitment process for appointment to the posts of graduate and postgraduate teachers in high schools and high secondary schools in terms of the advertisement challenge in the writ petition or any other advertisements issued for appointment to the post of graduate and postgraduate teachers in high schools and high secondary schools. Third, this court would also like to observe that though the petitioners had initially submitted for allowing them to take part in the recruitment process without insisting upon the TET qualification and that their selection may be subject to subsequent possession of TET qualification to which this court would have agreed. However, in view of the decision rendered by the division bench of this court under similar circumstances and referred to above, instead of allowing the petitioners to take part in the recruitment process subject to their qualifying in TET examination, they shall be allowed to appear in the TET examination and only after they are found successful in the TET examination to be held as directed above, the recruitment process will be initiated. Accordingly, it is declared that till then, the recruitment process initiated by the impugned advertisement dated so and so and any other advertisement for appointment to the post of graduate teachers and postgraduate teachers in higher school and high secondary school shall be kept in abeyance. My lord, my case at present, there are two cases. Over here, as I've already pointed out in the short notes, my lord, the TET was conducted, number of incumbent passed. In fact, in respect of graduate teachers, that is the first page of the short note, post release were more than the number passed. Post releases are almost 14,033 and 13,905 is the part of the writ petition, though only total pass is 12,000. So while of this recruitment carried on, and passing TET is a qualification, is not an entitlement for the job. So whatever they have done, whoever came through the appointment, they have been appointed. Similarly happened in the postgraduate scenario, my lord. Now the only thing, these petitioners, they are qualified. They got their graduation, post-graduation, B.Ed, and most of them, my lord, they got through the B.Ed 2021-2022. What happened, my lord? As for graduation, the last 3 years no TET, and for post-graduation, 2 years no TET. Suddenly the recruitment process has come up. And my lord, if my lord sees that the posts now have been earmarked for the graduate cadre, that is about 7,755 in the advertisement, and through advertisement, my lord, I did not make it a part of it, 7,725. But if we look at the number of left out candidates, is the state government in number one saying
whoever is left out, we are going to absorb them. If that is the scenario, then in every advertisement saying that TET is not the criteria or entitlement to the appointment, it is only a qualifying criteria. That vanishes. And we are before my lord only asking for the one thing. The state government should give us a chance to sit for the TET, get qualified, and then the state government should proceed with the recruitment process. Only this much, my lord. Our prayer is this much. We should be able to, and we are totally covered by this single bench judgment, which I referred just now, my lord. It is, otherwise we can say, issue is no longer as integral, my lord. It is already covered by this decision, my lord. Exactly similar circumstances. That's all, my lord.
I'll cut short the long story, Lordship. If we take into the number of petitioners here, 24 number of petitioners. We have advertised for about 9,800. And today it has come basically for the motion stage. So Lordship may be pleased to issue notice. And in respect of this 24 posts, we are not going to fill up this 24 number of posts. If they finally succeed, they will definitely come and give their applications and fight for the selection.
Problem is, they don't have that.
They do not have that. Without that also, because we already have substantial number of TET qualified persons, and all these schools are having a lot of vacancies. We are having a lot of problem. We are not in a position to conduct TET at this moment because that will consume another 8 months to 10 months. Another thought is that of the government is that, Lordship, we are going to abolish TET very soon by amending the rules, the statutory rules under 309. Thereafter, the selection process will be basically on the basis of written test as well as the marks obtained in various other examinations without TET. So that is in the pipeline. So their right is protected because they are 24 in number. The other case, I think 300 in number. Lordship may?
No, 36.
36. We can keep to 100 posts aside, not in from the realm of this selection process. At this interim stage. Otherwise, I have a case to counter. The judgment which my learned friend is showing, in that situation, Lordship, that TET was not been conducted for 7 long years. And there also certain riders were given, which we have followed here. I'm not going to enter into that arguments at this stage. So today, if at all Lordship is pleased to give any interim protection, all the petitioners' right can be protected because they cannot claim for 9,000 posts. Their claim will be against only 1 post. So all the persons who are before this honorable court will not consider those posts for the selection of the present recruitment process. Total 60. If Lordship gives 75 also, I have no difficulty. That is on instruction I am submitting.
How about letting them apply?
There will be 2 different categories then. Others will have TET, they will have no TET.
Then they can get the TET. After getting the TET only, you'll
without TET, because the marks now present selection process do not have written test. We are taking marks from various stages of their examinations. So TET will also have a particular marking system.
Yeah.
And these posts, not all of the posts are newly created posts. These posts belongs to prior to their getting graduation or post-graduation or B.Ed degree. These are old posts. At that point of time, had there been no COVID, these posts would have been filled up in 2021 itself. Because of COVID, there is a delay. The students should not suffer, and they should not also suffer, Lordship. They should be more than happy. We are giving full leeway to them.
My lord, the submission made by learned AG, my lord, possibly as far as the petitioners are concerned, if we are protected, we can't have anything more to say. But the only thing is that I still apprise this honorable court. My lord, having the present situation and this learned single judge's decision before my lord, would your lordship be pleased to allow them to continue with the recruitment process as they initiated?
And secondly, keeping another thing in the background, the number of, after the High Court's decision to conduct TET and go for the recruitment, the number of person passed and number of posts released for those persons. It seems, my lord, for graduate, though 12,000 person passed, the post release was 13,000. State is not before my lord saying that out of the 12,000 we have appointed 10, only 2.5 left. Or in respect of postgraduate, if you see 2,584 numbers of candidates passed and 2,893 passed. Second page, my lord, in my note.
2,893 part.
There are 6 million.
My lord got it. Para 5, the serial number 5. 2,893 passed and total post released for those were, my lord, 2,584. It is about only 300 left. But if we say 300 left, at the same time saying that it is not the
Advocate General, if we go with your suggestion, when are you going to conduct the TET exam?
Most probably there will be no further TET because there is a vast difference between elementary education and secondary education. In elementary education, lordship, we are governed by the Right to Education Act, Right to Children's Education Act of 2009, where it is mandatory to have TET for all teachers. So far as that is a central legislation, and the state legislation is also in the same line. Here, there is no such central legislation which is binding the state to have TET for the graduate and postgraduate teachers. State on its own, in our secondary rules, inserted the requirement of TET. Very soon, the process has already started, lordship, that we are going to waive TET for the future recruitment process. Instead of TET, lordship, we are going to have written test. Till now, there is no written test. We always have the scrutiny of the marks, the tabulation of the marks from matriculation, higher secondary, graduation, BA, and the TET examination. On the basis of those marks, we recruit the persons and we select the persons. There is no written test, but we are going to introduce written test in the secondary education and postgraduate teachers recruitment process instead of TET. That will take some time, lordship, maybe 8 months to 1 year time, because we have to go through a certain process to amend the rule and bring new rule into place. And in the meantime, the students will suffer. We cannot allow the schools to have less number of teachers because some persons are fighting for this case. We are protecting their interest. How many persons are before this honorable court? That number of posts we are not going to fill up. We'll keep that intact. If finally lordship directs that for them, without that also we can conduct the recruitment process, we'll do that. They are newly qualified persons. The post, majority of the posts belongs to prior to their acquiring the qualification.
In your petition, this present petition is for postgraduate teachers.
Graduate and postgraduate, my lord. My lord, after hearing the learned,
there are different types of advertisement, different rules are governing. They cannot amalgamate. This petition is not maintainable at all in that present form. Different causes of actions have arisen.
If the learned AG goes for the technicality of the repetition on the ground of cause of action and maintainability, I'm not going to say anything. But only thing is that, my lord, what presentation is given before the court? Is it that we are going to absorb all the TET pass candidates who passed earlier? Number one. If that is not the criteria, there is no reason they should proceed with this recruitment, because most of the persons have been already absorbed in view of the earlier round of litigation.
That is an incorrect statement, lordship. There is no absorption.
You are applying for the graduate teachers post and postgraduate teachers post. Now, how do I know this?
My lord, this is I found out, my lord. All are ready to apply for the graduate teachers out of the 16, both the repetitions. And secondly, 53 of them are also desirous to apply for the PGT also, my lord. 60 all graduate. They are all graduates, so they will apply for the graduate. And out of the 60, 53 also are desirous to apply for the PGT. But my lord, one thing your lordship is aware now, that it might take 1 year. They may hold the TET, keeping the posts aside for us. What does it mean? They are going to keep they might go for the TET for us, or may not go at all. But what I understand from the version of the learned AG, my lord, that ultimately they're going to scrap that requirement of TET from the secondary education. That will take 8 to 10 months. And after that, what? That means the posts will be there. This post will not be filled up. But we will remain idle. We will not be able to take part, we will not be able to participate in any kind of a recruitment process till it is wiped out or not wiped out. But the present scenario as on date, there are 4 advertisements in respect of graduate and postgraduate teachers, and similarly situated situations. There was a judgment passed by this honorable court, taking view of the writ appeal. And this honorable court stopped that procedure and said, you go for the TET. Otherwise, simple, my lord, if they are thinking of wiping out the TET, that is a matter of, as far as I understand, within 1 week, everything should be wiped out and go with this advertisement afresh, allow everybody to appear, but TET is not required. But admittedly 1 year, what we will do, my lord? My lord, one thing, the educated unemployed youths are suffering. There is no job. When there is an opportunity of job, they are asking for what? Give us a chance to avail that. They are not asking for the job directly. And it is obligatory on the state to hold the TET every year. Because NCT made mandatory for elementary education, not for the secondary education. It is our own department smartly put the TET in the secondary department rule. If you are smart enough, now it is on your obligation to hold the TET every year. These boys who come out successfully, they should have opportunity every year.
Yes, Advocate General, I think
Lordship,
this requirement of TET, if it is only a state legislation.
It is a state legislation. I'm simplifying the case now. Suppose there are 100 posts available with us. We are giving the advertisement for 100 posts. We have substantial number of TET qualified persons. They will definitely apply and they will continue. If a new TET is also conducted, this 10%, suppose 75% are already having TET. So they will not apply for fresh TET examination, or if somebody wants to upgrade their marks, they can apply. These 25% will not come into the realm of this recruitment process. But what I am suggesting before this honorable court, that we are going to hold TET and the recruitment process that has already been conducted for the recruitment of 75% post. Their case, lordship will definitely examine whether they have an enforceable right or not. That judgment of the earlier situation is totally different. He is harping upon NCT guidelines. NCT guidelines is not applicable here. These are the fundamental things which is confusing the honorable court. NCT requirement is only for the elementary education, which has the fountain and the source comes from the RTA Act of 2009, which is applicable only up to the class 8 level. That is elementary. So now what I am submitting is that if they succeed, if finally lordship directs that whole TET for them also, we are going to do it. But for that, the total number of posts, they are suppose they have 50 or 75 number of persons. For 50 or 75 number of persons, they can apply for those 75% posts. The posts are already there. Those who are already acquired TET and the school's requirement to have immediate teachers, that is having a public interest. Somebody may not have TET at this stage. Under the recruitment advertisement, lordship, they are not qualified. They are not eligible today.
That also you are equally blamed. You have to be equally blamed.
We cannot be blamed because
you did not conduct the TET exam.
There is no, his submission is that every year TET has to be conducted. Under which guideline?
No, that is, you are talking about elementary.
That is elementary. This is not elementary.
But at least you should conduct it. So
We are
this type of petitioner, they don't suffer.
They are not going to suffer.
Now the court is weighing the public interest also.
Absolutely.
The interest of the petitioners.
Absolutely.
You're weighing that now.
That is why we are conceding. Otherwise, I would not have conceded. That is why I'm conceding. Because the elementary education, there is a guideline rule, in the guideline, serial number 10 and 11, very clearly says that every year you have to conduct that. And if you don't conduct that, then allow cited. That is central TET. Those things are not before this honorable court. You cannot hire or import certain legislations or certain sub-legislations into the present situation because these are not applicable here. The law is totally different. The law which governed the earlier writ petitions and the writ division bench judgment, Lordship, it is on the basis of RTA Act as well as the guidelines of 23rd August 2010.
Take down. Item 54. Mr. J. Applicant, can you hear me? Also, Mr. Advocate General, appearing for Assistant Prime Minister, SMPT.
Yes, Joseph. 1, 2, and member.
We are appearing for all the respondents.
Appearing for all the. How long will you take to file your affidavit?
My affidavit, Lordship, if Lordship is giving us, I'll take 2 days time to file it.
This respondents are allowed 1 week. This matter after 2 weeks. In the interim, it is direct. The 60 posts of graduate teacher. Graduate teacher. 60 posts of graduate.
60.
60.
60 graduate teachers and 53 postgraduate.
He is totally confused, Lordship. 2 subsequent adverts are not part of the record. He is only challenging the 28th December's advertisement. 2 subsequent advertisement he is saying verbally, but these are not part of record.
I'm
Number
just
1.
saying whatever it is, and 53 posts of post shall not be filled until further.
Deeply obliged, Lordship.
What is in the IA and the other item 13?
My lord, this IA, what happened, my lord, in the writ petition? In the writ petition at that point of time, the date for online submission of application was not there. On 13th, the matter was heard by this court.
Okay.
And on 14th, actually, that guideline came. So we incorporated that guideline in this miscellaneous application, my lord. And to bring before the court, my lord, we have added these 2 affidavits. My lord, this annexure 32, page 32 annexure.
No, this your other writ petition, item 13.
This is part of, this can be treated as a part of the writ petition, that one, my lord.
List the matter after 2 weeks along with WPC number 443 of 2023 and IA number 481 of 20.
Highly obliged, Lord.
My lord, if your lordship is pleased to put your lordship as the state government to produce before the court at least 1 instruction, my lord.
That they will come with the affidavit.
Whatever is required from the petition will definitely disclose. Lordship is passing it in both the cases.
I'm passing in both.
Both the highly obliged.
My lord, this writ petition 1047 will be the leading case, my lord.
Yes. 60. I passed the order in 1047.
Yes.
And I've said to list it along with this.
Yes. My lord, date may kindly be fixed. Fixed date may kindly be given. Matter is urgent. Urgency is there.
Lords, we'll file it within this week. We will file it.
Okay. 16th?
16th, Lord.
March.
Deeply obliged, Lord.
Deeply obliged.
Item 1 of production list motion. Pranjal Saikia and another.
Hey, please.
What is this?
Well, under very unfortunate circumstances, the petitioners are before your lordship. But just to give a background, there was a scheme by the education department, which was known as strengthening and improvement of quality secondary education in the state. And under this was in fact ultimately incorporated in the rules also. Under this scheme, basically to improve the quality of education, there were qualified teachers who were appointed on contractual basis. They have been continuing since then, right? From 2010, this scheme came in 2010. They have, even now they are continuing. Now in 2012, your lordship is aware, the rules underwent an amendment. As per the amendment, these contractual teachers who were appointed under the scheme, they were supposed to be given preference of 50 marks. However, by the same rules, the requirement of TET qualification was also brought in. But unfortunately, as your lordship must have been, since your lordship is taking up this bench, your lordship must be aware, this TET examination has not been held right from 2012. There were advertisements issued. 2014, there was an advertisement. It was not held. These people applied. The exams were not conducted. Ultimately, 2017, a second advertisement came. They said that people who had applied in 2014, they need not even apply. They did not pay any fee. But again, 2017 advertisement also did not culminate in this examination. 2019, another advertisement came. This time exams were held and we qualified. Unfortunately, what happened in the meantime, well, after the TET, we acquired the TET qualification, the advertisement for recruitment that came, they put an upper age limit of 40 years. Whereas all along earlier, we were, otherwise the purpose of appearing in TET gets defeated. Why do we get the qualification? Only for regular recruitment. Now, once that cap was put, we challenged the advertisement itself. And this honorable court found that it is not for their fault that you are the ones who have not been able to hold the TET. And there is a OM for relaxation of the age. This honorable court directed that you consider individual cases. They will make applications, separate applications for condonation of the age, relaxation of the age. And the secretary was directed specifically to look into the grievances individually based on the applications received. We had also applied. And reasoned orders to be passed thereon. Nothing was done. Now a lot of fresh advertisement has been brought in, where again that age limit has been put. Our earlier direction issued by this honorable court, that remains to be taken to its logical conclusion. Now a new advertisement comes, again they have put an age bar. And it is that clause putting the age bar that we have challenged in this case. May I just briefly, quickly indicate the documents? If your lordship will first come to page 37. Annexure A at page 37, your lordship will find that this is pursuant to a cabinet decision. In pursuance of the cabinet decision to strengthen and improve the quality of secondary education and to engage 3 additional teachers on contractual basis in the core subjects, that is English, etc., etc. Next, one is important. This scheme will be called as the scheme to strengthen and improve the quality of secondary education in the state of Assam. And now, if your lordship will kindly turn to page 39, at the very top, your lordship will find that the age limit fixed for this scheme was 50 years. Indian citizen below 50 years of age. So anyone who was below 50 years was entitled if he had the requisite qualification. We got appointed, and that is when the rules came. If your lordship will kindly have the rules for a moment. If your lordship will come to the 2003 rules, I think we are holding the same book. If your lordship will come to page 363. And if your lordship
kindly turns to Rule 8 first. Rule 8 starts at 372. And we are concerned with sub-rule 6 thereof, which your lordship will find at page 374.
Yes.
Sub-rule 6 first. The teachers engaged on contractual basis in a provincialized higher secondary high school under the scheme of strengthening of secondary education shall be given preference for recruitment to the post of graduate teachers by awarding total 50 bonus marks for their services as contractual teachers. That is 25 marks for 1 year and another 25 marks for completion of 2 years of service as contractual teacher, subject to consideration for a maximum period of 2 years. Now, if your lordship kindly turns to the age requirement, Rule 9. A candidate for direct recruitment to the service shall be within the age limit prescribed by the government in the personnel department from time to time, provided that the upper age may be relaxed for the candidate belonging to the scheduled caste and scheduled tribes as per government order issued from time to time. And next is important. The upper age limit may also be relaxed in case of candidates who are working under the scheme of strengthening of secondary education on contractual terms for a maximum period up to 5 years. And Rule 10 brought in TET for the first time. Now, my lord, after this, the first advertisement came on 30/6/2014, which your lordship will find at page 43. This is the first advertisement for TET, 30th of June 2014. No exams were conducted. Then, if your lordship will come to the second advertisement, which your lordship will find at page 48. This is the second advertisement. This is dated 31/7/2017. And if your lordship kindly turns the page to page 49, your lordship will find this will indicate that this is in a sense a continuation of the 2014 advertisement. There are bullet points, my lord. There is at the top, your lordship will find a heading. However, all intending candidates may note that there are those bullet points. Your lordship will come to the 5th bullet point. The candidates who have applied earlier by the advertisement number so-and-so dated 30/6/2014 need not pay the fee for this step, provided the applicant have to mention his or her online application number against our earlier advertisement number so-and-so dated so-and-so in the form. So the persons who had applied under the 2014 advertisement, they need not apply afresh, they need not pay any fees, etc. And if your lordship kindly turns to page 50, your lordship will find that the age limit fixed is, upper age limit is 43 years for general category candidates. Subclause C, who can apply? Subclause C, age of candidate must not be less than 18 years of age and not more above 43 years of age as on so-and-so. Now, my lord, again, this also did not reach its logical conclusion. Then the next advertisement came on 13/11/2019, which your lordship will find at page 52.
Yeah.
And clause 1 itself is important, my lord. It is for general information that the government of Assam is going to conduct medium-wise TET for secondary level in pursuance of to our earlier advertisement wide number so-and-so dated 31/7/2017. So 2017 was a continuation of 2014. Now this makes it clear that this is a continuation of 2017. Now, if your lordship will kindly turn to page 53, your lordship will find again right in the middle in italics. However, all intending candidates may note that the third bullet point, your lordship will find there is a minimum age, but there is no maximum age. Minimum age is 21 years. Now, my lord, this ultimately was taken to its logical conclusion. We qualified TET. Now comes the advertisement, which your lordship will find at page 59. This is the advertisement for selection and appointment. In the chart at page 59, your lordship will note just one thing. The total vacancies advertised were 5746. This has a significance. I'll come to that a little later. And if your lordship kindly turns to page 61, at serial number 2, your lordship will find that they fix the upper age limit of 40. They allow people to appear in TET without fixing an upper age limit. That is how we applied. That is how we appeared, we qualified. Now, when it comes to recruiting, the only purpose for which TET is required is otherwise we could have merely continued on contractual basis. The only reason, under the rules, there is a requirement of TET as a mandatory qualification for being employed regularly. So that is how you allowed us to appear in TET. Now, when it comes to recruiting, you are putting an upper age cap of 40 years. What purpose would it serve for us to have appeared and qualified? Now, that is why we challenge this. And when we challenge this, this is the order, judgment that has been passed by this Honorable Court. It starts at page 80. Well, there were a series of writ petitions. And if your lordship kindly, the cause title itself runs into several pages since there were several cases tagged together. If your lordship will kindly come to page 145, the judgment starts at page 140. The relevant portion is at page 145, paragraph 13. Yeah. Para 13. Clause 4 of the notification is quoted just above that. The clause 4 of the notification dated 3/5/1951 provides that for condoning the upper age limit, the authorities are required to consider whether it is necessary in the interest of fair dealing or in the public interest that the upper age limit can be condoned either by the governor or in other case by the head of the department. The head of the department of the secondary education would be the appropriate authority to condone the upper age limit of the present petitioners for the purpose of advertisement dated 12/9/2020. In the circumstance, we are of the view that the ends of justice would be met on the writ petitioners filing their individual applications before the secretary to the government of Assam in the secondary education department, making their respective claims as to why the upper age limit in the context of the advertisement dated 12/9/20 should be condoned. Upon the individual applications being submitted, the secretary to the government of Assam in the secondary education department shall take note of the provisions of clause 4 of the notification dated 3/5/51 and deal with the applications in the interest of fair dealing as well as in the public interest. And next, what would comprise of interest of fair dealing has been discussed in the next paragraph, my lord. And ultimately a direction was issued at paragraph 18, 17 and 18, that these applications should be considered. These applications are yet to be considered in respect of the earlier advertisement. And my specific instruction is that out of the 5,746 posts that were advertised in the first round of advertisement of 2020, they could fill up only 4,190. So there are a large number of vacancies existing from the earlier round of selection. And now they have advertised in the impugned advertisement. If your lordship will kindly come to page 149, the impugned advertisement. Quota 7,500. Page 151.
Second line of the right side.
This is the type copy. Your lordship will find that 7,500 posts are now being advertised. Interim moderator display around the
2003 rules of strengthening of very
5963 or 6479.
Hmm?
6479.
Now, my lord, here again,
upper age limit has been fixed, page 154, 40 years. In the earlier round, when we had approached this honorable court, this was the interim protection that was granted. At this stage, my lord, I certainly don't intend to have the entire process stalled. This will protect our interest also. No prejudice will be caused to them. Page 66, if your lordship comes. In the earlier round of litigations, this was the limited interim protection that was granted. The order starts at page 64, and the operative portion your lordship will find at page 67, the last paragraph. As the learned counsels for the respondents have accepted notice, no formal notice be issued, however, extra copies be served, etc., etc. Since this court is in session of the matter and the issues raised, it is directed that the respondents will file their necessary counter by returnable date. In the meantime, since the last date of submission of the online application form is so-and-so, the petitioners are permitted to submit offline forms in response to the advertisement dated so-and-so, response number 3, namely Directorate of Secondary Education, etc. This benefit of the order will operate till 5 o'clock on so-and-so in the office of the Director of Secondary Education. So, and in respect of the present advertisement, your lordship will examine the whole matter because there is already a direction. They were bound to comply with that direction, that individual applications will be considered. So all these aspects will be on touching upon the merits. So your lordship will examine on the merits of the case. In the meantime, this limited protection that in connection with this advertisement, we may be allowed to submit our offline applications, and it will be subject to outcome of the petition. That limited protection, my lord, I think no prejudice is going to be caused to them also. And we can also that way at least participate. And if the case goes in our favor, appropriate orders can be passed.
Rule 9 of the Assam Secondary Education Rules 2003. Here it is very clearly said, the upper age limit may also be relaxed in case of candidates who are working under the scheme of strengthening of secondary education on contractual terms for a maximum period of 5 years. So although we have fixed 40 years, definitely both of them are, I think, 43 and 44 years. They will be covered under this age, the proviso therein. So along with an offline application, they should file an application requesting for condoning their age or giving them the relaxation in terms of Rule 9 of the 2012 rules. So I have no difficulty.
Fair enough. That's a very fair submission by my
I have no difficulty. They are eligible under the rules. I do not know where they should have filed an application here instead of filing a.
In respect of the earlier advertisement, we have already filed. That has not been considered.
Then if it was not passed, then they could have filed a contempt case. That has no link with the present situation.
Our difficulty is we are losing our age. So we are anxious, somehow or the other, if we are otherwise, since we are entitled.
Consider the earlier time, they should have pursued that. Or maybe my learned senior friend has not been properly inspected. They may not have pursued or they may not have got selection.
No, they have not been considered.
5 years selection. Difficulty is 2018 rules or 89.
Perhaps, one difficulty that may arise is because in 2018 rules, that provision as contained in the proviso of the 2003 rules, that is not there in the 2018 rules.
Lordship, I am sorry because it has been repealed by 2018 rules.
Yes.
So my learned friend was showing 2003 rules as a present rule. This has no application now. So I have to revise my submission. In any case, I agree to his submitting the application offline with a prayer for condoning the age. Otherwise, Lordship, if the 2018 rules, if it is not there, then he is not eligible under the statutory provisions of the law.
That is why let it be subject to outcome.
I trusted my learned senior friend Because when he was placing this 2003 rules, I thought it is the rule which is in force. It is not in force.
No.
It
That
has
is
been-
why I
the
pointed
repeal
out.
clause has been quoted. That is why I pointed out the 2018 rules. Now it has been clarified. In any case, let them submit it offline, and in the meantime, Lordship will examine.
Assisted by Mr.
E. Decalogue.
D. Decker. Also heard for the second page. For all the respondents? No. Second page.
For all. All Lordship. Yes,
One is.
all,
Yes,
all
yes.
one.
For
All,
the-
all. তোমাকে কিন্তু কন্টেম্পট এখন ফাইল করে দিবা দেই ফাইল কৰি পেলাই এটা লগত
petitioners. Both the writ petition. You are both TET qualified, isn't it?
Yes.
Are all TET qualified candidates who intend to apply in response to the, where's that advertisement? To the advertisement.
Page 144 or 45.
One.
It is at page 150.
One.
150. The impugned advertisement is at page 149. It starts from 149. The type copy is at 151.
Response to the advertisement. This is number. And it's in response to advertisement number GB-ESP oblique advertisements within bracket PC and PTC close bracket /1 2022/9. Stated, this is what
It is advertisement was issued on 28th of December. 28/12/2022.
12/22. However, they are aggrieved by the bar of upper age limit of where was that age limit?
Page 154, upper age limit of 40 years, because both are general category candidates in this case.
Upper age limit of 40 years.
Page 154, clause 2.
Upper age limit of 40 years in respect of unreserved candidate. This is S on, no date. S on 1st December. 2020.
As on 1/1/22.
Yes.
1st this January, Lordship.
1st January.
Lordship.
2020. Issue note. Then we can issue. Then we can separate all the. After hearing the full and by way of an increment, it is directed that both the writ may be permitted to make the application offline. Before the last date. Tomorrow isn't it?
Tomorrow is the last day.
In the meantime, petitioners are also directed to make a representative before the concerned authority.
Concerned authority.
The concerned for condonation of the case.
under appropriate rules and
Under-
guidelines.
Under that one 1951 notification or
1951. There are subsequent
Under-
guidelines also.
under
Under the appropriate notifications issued by personnel department.
the appropriate by the personal department government within a period of
That representation also will make it immediately. Go along with the application. Along with the application itself will.
along with the file form. The representation shall be considered by the concerned
Within 15 days.
within 15 days and passed. This the method taken on. How long will it take?
2 weeks time may be given. Lord.
Is the method taken on? 17th March.
Lordship. Yes, I'm only praying that in case they are selected, it will be subject to final outcome of the repeal, that observation. So, in case they are selected.
In the event petitioners are selected, their selection shall be subject to the outcome.
Highly obliged. Item number 3 in the production list, Madam. This is also identical. Same.
How many petitioners?
The 47.
In item number 3, there are 47 petitions.
But they are not contractual teachers. They are
47.
But I am told that they are not contractual teachers. They are not contractual. But they are covered by the earlier judgment of this honorable.
What about item 2? Same.
Item 3.
Item
2 is no.
same. Only make.
Empty the heaven.
Item 2 of production list, Mohammed Sultan Ahmed.
Same matter.
No, my lord, this is a Madrasa tat, my lord. Slightly different, my lord. The advertisement is also same. The issue is slightly different.
With the advertisement,
My lord may be pleased to find the advertisement at page 96, my lord. Page 96, my lord, is the advertisement dated 27/12/2022. Lord, the applications are invited from so and so for filling up 1385 vacancies of the postgraduate teachers in the different provincialized secondary schools. Now, my lord, we are only concerned, my lord, with the Arabic, my lord, postgraduate teacher in the district of Karimganj, and my lord may directly come to kindly page 110, my lord. Page 110, it is for the district of Karimganj, and the post, my lord, has been earmarked as Arabic. 4 numbers of posts are there in the Karimganj district, my lord. As we are from the Karimganj district, my lord, so we are intending to apply in the Karimganj district. Now, my lord, the difficulty is that if my lord may be pleased to take up the page 96, annexure 12, the conditions of recruitment, my lord, may I draw your lordship's kind attention to the conditions of recruitment. At clause 2, my lord, the applicant should have appeared and passed the higher secondary teachers eligibility test in the concerned cadre conducted by the government, scoring a minimum of 60% mark in case of unreserved category candidate and minimum of 55% marks in case of scheduled caste and so category candidate. Now, my lord, the difficulty is that the higher secondary teachers eligibility test has been specifically provided in this advertisement. Now, my lord, we are, although a postgraduate TET qualified candidate in the Madrasa stream, therefore, my lord, there is no option has been given in the online mode for the apply of these candidates. My lord, what has happened there, the history is long back, my lord, as regards the conduct of the Madrasa TET examination. My lord, what has happened, the government in the year 2012 initiated a recruitment process for the filling up of the post of the various vacant posts in the Madrasa educational institutions, my lord, which were in existence at that relevant period of time. Now, my lord, a PIL had been filed before this honorable court, challenging that recruitment process that without the TET in a secondary level schools, there cannot be any appointment, my lord, as the secondary level schools consist from upper primary to the secondary level. Accordingly, my lord, when the PIL was adjudicating by this honorable court, the government has accepted their fault and said that yes, we are also going to conduct the TET examination for this Madrasa educational institution. Accordingly, my lord, this advertisement at page 51, my lord, may kindly have a look. Annexure 1, my lord. This is the advertisement issued, my lord. Did the teacher eligibility test of the Madrasa education for the unreserved post in provincialized Madrasa institution. My lord, this advertisement, my lord, may skip the relevant part, and the various category of post has also been earmarked that in what category of post they are going to conduct the TET, my lord. We are concerned with the lecturer and MM. At page number 51, my lord, eligibility criteria for teachers in Madrasa institution is the lecturer and MM. And MM teacher, my lord, MM is a, my lord, postgraduate degree, which has also been recognized by the state of Assam that MM, those candidate passed. It is Mumtazul Muhaddisin, my lord. It is an Arabic term. And the person who got this qualification or acquired this qualification is treated to be a postgraduate in the Arabic stream, my lord. Accordingly, my lord, therefore, those candidates who has passed the MM TET, my lord, they are also being treated as a postgraduate, my lord, TET pass candidate. Now, my lord, this pattern has also been earmarked in page 54 also, my lord, that what course curriculum and subject they are required to be passed out for this TET examination. At page 54, my lord, may be pleased to find in table number 1A and B is the category for lecturer as well as the MM category, my lord. Now, the present batch of petitioners, my lord, passed out this MM category teacher, MM category TET. At page 58 is our certificate, my lord. My lord has got it, my lord. At page 58, my lord, may kindly see this is the name of the candidate and post against which appeared for MM assistant teacher, and I have secured, my lord, 72% of marks out of 100. And accordingly, my lord, the government has time to time initiated the recruitment process for the purpose of, my lord, conducting the my lord, recruitment process from upper primary to the secondary level. Sometime, my lord, they allowed this Madrasa TET pass candidate to participate in the recruitment process, and even appointment has also been given to the some of the candidates. Now, my lord, subsequently in the year 2019, the government has come up with a policy that we are not going to recruit any more Madrasa TET qualified candidates in the upper primary to the secondary level, because the course curriculum and the structure of the general TET and the Madrasa TET are different. So accordingly, my lord, that decision of this the government has been put into challenge before this honorable court. And while, my lord, this honorable court was examining the issue, my lord, the respected Advocate General made a submission before this honorable court that we are going to consider those candidates who has passed out in the Arabic stream, and we are going to recruit those persons specifically for the only Arabic category of post. That has also been recorded in a judgment delivered by this honorable court, my lord. If my lord may be pleased to take up a relevant part of that judgment, my lord. Yes. My lord, when this issue was examining by this honorable court that whether this Madrasa TET qualified candidate can be accommodated in the general schools, this honorable court has held that the decision of the state government cannot be interfered with. It is a policy decision of the government. But my lord, while recording the judgment, my lord may straight away come to page 148, my lord. The second last page, my lord. Page 148, paragraph 10, my lord, I am relying on. A stand has been taken by the learned Advocate General Assam that the MTET qualified Arabic and Hindi teachers were allowed to participate in the selection process initiated by advertisement dated 11/3/2018, as there were the dearth of candidates. The same position was also clarified by the notification dated so-and-so. Subsequent to the issuance of the impugned notification dated so-and-so, another notification was issued, further clarifying that MTET, FM, pre-senior and Hindi were treated to be qualified for the Arabic and Hindi teachers in ME school. Therefore, this court is not interfering with the such decision not being under challenge. So, my lord, it was a categorical statement by the respected learned Advocate General that MTET Arabic qualified candidate will be given the benefit. Now, my lord, another situation arises. Before this advertisement, my lord, another advertisement was issued by this by the state government, my lord. My lord, may kindly turn to page 80, my lord. Page 80 of my writ petition, my lord, an advertisement dated 7/9/2021. My lord has got it, my lord.
Yes.
And I am, my lord, bringing your lordship's kind attention to serial number 5. My lord, it is in the Arabic category. And herein, my lord, 37 numbers of posts in the entire state had been earmarked for the purpose of recruitment in the postgraduate teacher. Now, my lord, when we were also the, my lord, Madrasa TET qualified candidate, the provision was also not there. My lord, may kindly turn to page 81. And in this condition also, my lord, the candidate shall have to appear and pass the higher secondary teacher eligibility test in the concerned cadre conducted by the government, scoring minimum 60% of marks. So, my lord, being agreed with this decision that as there is no provision for the Madrasa TET qualified candidate, we approach before this honorable court. And this honorable court, my lord, may be pleased to find an order has been passed, my lord, at page 87, my lord. The same petitioner earlier also approached before this honorable court, my lord.
Yes.
My lord, the three petitioner herein project that they have passed out the Madrasa teacher eligibility test herein after treated as MTET for short held in January 2015 in the category of the lecturer and Mumtazul Muhaddisin herein after referred to as for short as assistant teacher. It is projected that in previous recruitment drive, the MTET qualified lecturer and the teachers were allowed to participate in the recruitment for the filling up the post of the assistant teachers of the primary as well as the secondary level schools, that is the high schools and higher secondary school. It is also projected that wide notification dated 21/11/2018 issued by the respondent number 1, it was provided that the MTET qualified candidates were eligible to apply for the post of assistant teacher BA, assistant teacher BSc, and Assamese language teachers in the high schools and higher secondary schools. However, wide notification dated 5/1/2019, the respondent number 1 had cancelled his earlier notification dated so-and-so, which is stated to be the subject matter of challenge in WPC number 1051 of 2019, which is pending for disposal before this honorable court. Now, my lord, after considering all the issues, my lord may kindly come to directly, my lord, at page number 90, paragraph 7, I am referring, my lord. In view of the said submission made by the learned standing counsel for the secondary education department in the interim and till the next date of listing, it is provided that only in the event in the present recruitment drive of undertaken pursuant to the advertisement dated 7/9/2021, the respondent authorities envisage the recruitment of the postgraduate/graduate teachers in Arabic language in the high schools and higher secondary school. The respondent authorities would devise way and means to accept the candidature of the petitioners who claim to be holding the MTET qualification certificates, if required by accepting offline application. However, in the event the respondent authorities do not intend to make the recruitment of the postgraduate/graduate teachers in Arabic languages in the high schools and higher secondary school, then the aforesaid interim direction would not be applicable. But my lord, as I have already brought your lordship's kind notice that for 34 numbers of Arabic teachers has been proposed to my lord, brought under this recruitment process. But even my lord, after this interim order, we did apply, but our applications, my lord, was not considered by the department. Thereafter, my lord, we again came up, my lord, with an interlocutory application to bring into the kind notice of this honorable court, my lord. And this honorable court, after considering the entire issue, my lord, may kindly turn to page 94, my lord, paragraph 5. My lord has got it, my lord, page 94, paragraph 5, my lord. By the present I, the applicants who are the writ petitioner has made the following prayers in the so-and-so, my lord. After considering the prayer made in the present IA and also taking into consideration the interim passed by this court on 8/10/2021 in WPC number so-and-so, this court is of the considered opinion that no further direction requires to be issued to the respondent. It is made clear that in the event the respondent proceeds to fill up the post of postgraduate Arabic teacher pursuant to the advertisement dated 7/9/2021, then the application made by the petitioner offline shall be considered. However, in the event the respondent decides to go for the separate recruitment trial with required to the postgraduate teachers in Arabic language, the application already made by the petitioner shall be taken into consideration. IA stands disposed of. Now, my lord, this order till date is holding the field, my lord. And now, my lord, they have come up with this advertisement, specifically specifying, my lord, that the category of the Arabic teachers in the postgraduate in Karimganj district is going to be, my lord, filled up. So, my lord, as we are in the category of the Arabic, as per the, my lord, stand taken by the government through the learned, my lord, respected Advocate General, that they will consider the Arabic. So we are also entitled to bring under the purview of this recruitment process, my lord. So we should be allowed to apply. And, my lord, our application can, my lord, examine, and that can be, my lord, subject to outcome of the final adjudication made by this, my lordship, my lord.
I am not sure from where my learned friend is making the submission that in Karimganj district, lordship, Arabic teachers will also be recruited. So this is an unlisted matter, lordship. I have to obtain instruction, but one advertisement which is a part of the record, I have found that this time teachers in arts, science, Sanskrit and Hindi are to be recruited under the present recruitment process. I have also verified what about Arabic and Persian, are they included in arts? They have very categorically Arabic is an elective subject, so this Arabic is not included, and Persian is a classical subject. So let me obtain instructions, let the matter come up tomorrow morning. If it is actually what my learned friend is submitting, that in Karimganj Arabic teachers will be recruited, my instructions, just now my friend has obtained all the instructions over telephone. There is no such recruitment for Arabic teachers. If that is the case, then he has no, he cannot have any grievance at all. So let the matter come up tomorrow at 10:30, lordship. I'll make it clear.
My lord, in the very advertisement, my lord, the list which I have appended, my lord, my respected friend perhaps has gone through, my lord, at page 102, category wise and the subject wise vacancy of the postgraduate teachers in provincialized schools in Assamese medium school, my lord. And it is the district subject oblique category Arabic, my lord, it is in Borpeta and Karimganj, my lord, may be pleased to find at page 110. Page 110, it is for the Karimganj district, Arabic, four numbers of post, my lord, has been here, my grand total at page 102, and my lord may kindly verify from page 110. 4 numbers of Arabic, my lord, clearly notified, my lord.
If I have another advertisement of the same date, where applications are invited from eligible Indian citizens under Article 5 to 8 of the Constitution and permanent residents of Assam for filling up of 7,500 vacant posts of graduate teachers within bracket arts, graduate teachers within bracket science, graduate teachers Hindi, and graduate teachers Sanskrit. I have this advertisement.
My lord, we are not
So that is
graduate.
why I'll clarify tomorrow morning at 10:30.
My lord, with all respect to my respected Advocate General, my lord, we are not concerned with the graduate, my lord. We are only concerned with the postgraduate subject.
When is the last date?
My lord, tomorrow is the last date up to 12 midnight.
Yes.
We can apply online, my lord. And my lord, if we apply offline, the last time fate is very pathetic, my lord. We applied the offline and offline forms are still lying in the office, my lord. No consideration, my lord.
And date was also notified quite far away.
My lord.
So they have come at the last 11th hour.
No, my lord,
In
this,
any case, I'll at
Mal-
10:30, this matter may be taken up.
my lord.
Highly obliged.
Tomorrow, my lord.
On writing slow.
Obliged, my lord.
All right.
With your lordship's leave, I'm mentioning the part heard matter which was fixed at 2 o'clock. Mr. Borpujari, who was to complete the arguments, This has been pending for a long time. He's ready, my lord, because I have completed my come. I'm told he's making a short submission. $57.
How long will take, Mr. Lord?
I will be only relying on my affidavit, my lord. Hardly 10 minutes.
Yes. Yes.
If my lord may be pleased to take up the affidavit filed by the finance department, my lord.
We have not got it.
Finance.
Finance. The deponent is my lord, one Sri Lila Kanto Bora. That's for the respondent number 3. If I may help my lord, record I can.
Respondent 3.
Respondent number 3, my lord, the deponent is one Sri Lila Kanto Bora.
Yes.
There, my lord will kindly come to paragraph 3. But I'm reading it, my lord. That is precisely the defense of the finance department. At the outset, the deponents did to state that the petitioner has been allowed by his administrative department, that is the Animal Husbandry and Veterinary Department, Kwasi Lian, to join as unit manager ICICI Prudential Life Insurance Company Limited, which is purely a private company, for 2 years from the date of release from the department, subject to submission of an undertaking to the effect that at the end of 2 years from the date of release from the department, he must revert back or resign from the parent department by letter dated 1/12/2005. But showing utter lack sense of responsibility expected from a government officer, and without waiting for formal order of the government, the petitioner had already joined the private company on 1/11/2005. After expiry of his 2 years Kwasilian period on 31/10/2007, he did not come to his parent department to join. Instead of joining, the petitioner filed a prior petition to the Commissioner and Secretary to the Government of Assam, Animal Husbandry and Veterinary Department on 31/10/2007, white copy annexure 6, to extend his Kwasilian period for another 5 years. As he had been looking after an important assignment in the ICICI Prudential Life Insurance Company Limited, which require utmost attention and involvement. So according to him, leaving the organization in the middle of the process would put lot of problem, which he felt would be against the organization policy and interest. So he should be given another 5 years quasi-lien by the department. After getting his prior petition, department had given several reminders, right dated 4/2/2008, 6/6/2008, and 26/2008 to join the parent department. But the petitioner did not respond to the government reminders and was keeping himself away from his duty under the state government with effect from 1/11/2007. Thereafter, he replied, right his letter dated 23/6/2008, that he was surprised for not considering his earlier petition dated so-and-so to the government, wherein he had requested the department to extend his quasi-lien period for another 5 years. He also mentioned in the said letter that it would be difficult to go back to his parent department unless and until the assignment of the private company was over. Thus, the petitioner was continuing his assignment in the ICICI Prudential Life Insurance Company, which is a private company, without any authority after the expiry of his quasi-lien period on 31/10/2007. Suddenly on 3/8/2009, the petitioner expressed his willingness to join his parent department as he had completed his assignment prior to the stipulated time in the ICICI Prudential Life Insurance Company Limited, which is a private company. Then the Director, Animal Husbandry and Veterinary Department forwarded the application of the petitioner to the Commissioner and Secretary, Animal Husbandry Department, and requested to take necessary action by Director's letter dated so-and-so. And thus necessary examinations were started in the department, and accordingly, views were taken from the Finance and Personnel B department. The petitioner filed a writ petition 6/31/2011 in this honorable court on obtaining the subsequent views offered by Personnel B, Judicial and Finance Department, as per honorable court's direction given in order dated 25/10/2011, while Annexure 1 of this affidavit in opposition. The Animal Husbandry Department has allowed the petitioner to join in the parent department, subject to the condition that he will not be entitled to any salary from the date of release from the private company till the date of joining the parent post, that is up to 28/12/2012. Subsequently, the Animal Husbandry and Veterinary Department had processed the file to Finance Department for regularizing the absence period by way of EL, HPL, EOL, etc. But the Finance Department did not consider it as the proposal is not covered by the rules. Also, since from so-and-so to so-and-so, Sri Rajiv Lahan was neither a government service nor on deputation, hence no leave can be granted to him for the said period. He was allowed to join in the parent department post on 29/10/2012. Therefore, the Finance Establishment A department communicated to the Veterinary Department white endorsement dated 7/10/2013 that the period from 1/11/2007 to 28/10/2012 for which no leave is admissible cannot be regularized, and that it will constitute a break in his service, and that it will have to be treated as diasnal under FR 18, read with Government of India's instruction under FR 18. Now, my lord, I pause here for a moment. Under FR 18, my lord, the maximum period can be 5 years, subject to approval of the government. Here is a case, my lord, only for first 2 years, my lord, it was given, my lord. The government had accorded approval for the first 2 years. For the next 3 years, subsequent 3 years, there is no approval per se, my lord, from the government. And that is the admitted position on record, my lord. I am reading it further, my lord. Here it may also be mentioned that the Honorable High Court, in order dated 25/10/2011, passed in WPC 631 of 2011, has specifically mentioned that the condition that Sri Rajiv Lahan, if allowed to resume his duties in the state government, will not be entitled to any salary from 1/11/2008 till the date of resumption of duty. Now that's in the earlier round of litigation, my lord, there was a categorical funding from this honorable post that you join, but you will not be allowed to, my lord, receive the salary. And that order has attained finality.
Where's that order?
My lord, that order will, my lord, will find. My lord, in that affidavit itself, lordship will kindly come to, my lord, page 18. Page 18. Lord, I am reading it. So and so, so and so, so and so. The petitioner is an officer of the Animal Husbandry Department. He was allowed to go on deputation on quasi-lien covering the period from 1/11/2005 to 31/10/2007. During the said period, he was serving in the ICICI Bank. Although the petitioner had prayed for extension for quasi-lien by another 1 year, but the government did not accede to the same, and he was directed to revert back to his original post. Irrespective such direction, the petitioner continues in the ICICI Bank for another 1 year, that is up to 31/10/2008. He was released from the bank with effect from 1/11/2008. Thereafter, although he wanted to join his parent department, he was not allowed to do so as he has overstayed the period covered by quasi-lien. Various pleas have been raised in the counter affidavits filed by the state government. The basic plea is that since the petitioner was not granted quasi-lien for the period of overstay, he could not have served in the bank, signed the government orders. However, the fact of the matter is that the services of the petitioner has not yet been terminated. In view of the above, both the learned State Council as well as the Standing Council Financial obtained direction from their respective authorities as to whether they are agreeable to allow the petitioner to resume his duties in the state government department on condition that he will not be entitled to any salary from 1/11/2008 till the date of resumption of duty. Thereafter, my lord, after this.
Where is this final order? Where's the final order of this?
The final order we have not annexed, my lord. Final order we have not annexed because.
Where's the final order?
The final order here, my lord, will not assume any significance in my aspect.
Why not? After that, only the final order will be passed.
Yes.
I want to see the final order.
Final order, of course, my lord, they are relying, my lord. They are relying on the final order. My lord, I am on the issue, my lord, that he will not be there. There is a categorical funding.
That is correct. That is why I'm asking, where is the final order?
That is, my lord.
You have a copy. You have a copy.
Yes, my lord, the final order is at page 68. My lord, one submission I'd like to make. There is no dispute regarding the factual part because when we moved the court, because we were not allowed to join. Why is the finance department not making a statement on that? Well, the finance department is very shrewd insofar as saying about the rules. We also know the rules. But what happened when I was willing to join and for 4 years, you don't allow me to join? Well, this is a case of, I had to approach the court. Well, if it was in the Western democracies, I would have been entitled to compensation for malfeasance and misfeasance.
Thereafter, my lord, after disposal of that writ petition, the petitioner had, my lord, finally he was allowed to join, and he had joined. Now, thereafter, my lord, the finance department has given the note, the decision of the finance, that my lord will find at page 20, the last page of the affidavit. This is our precise stand, my lord, on the matter. That I am reading it. This is a, my lord, endorsement, my lord, from the finance to the parent department. Since from 1/11/2007 to 28/10/2012, Sri Rajiv Lahan was not in government service nor on department, hence no leave can be granted to him for the said period. He was allowed to join the parent department post on 29/10/2012. The period from 1/11/2007 to 28/10/2012, for which no leave is admissible, cannot be regularized, and it will constitute a break in his service, and it will have to be treated as biasment under FR 18 with the Government of India's instruction inserted under FR 18. So therefore, my lord, the basic case of the petitioner at this stage is now, my lord, he wants a regularization of that period. This is where, my lord, the matter stands now.
Lordship will kindly appreciate, I am.
1 minute. Yes.
No, since my lord, I am not representing the parent department, but the views of the finance department was obtained, my lord, by the parent department as to whether that period can be regularized. The issue is only that, to that extent, my lord. We say it cannot be regularized because, my lord, number one, my lord, the petitioner had gone on deputation for first 2 years, my lord, not in a government department, my lord, it is absolutely a private company. And after 2 years, my lord, he didn't come back.
See, initially you gave him 2 years. He completed 2 years. He asked for 5 years. You did not allow.
My lord,
He continued there.
my lord.
Then on 3/8/2009, he said, I want to come in join. Now from 3/8/2009 up to 29/10/2012. Now this period is the period under consideration only.
Yes. Yes.
Now you tell us for what reason you did not allow him to join.
No, so far as my lord, the finance department is concerned, our views is that, my lord, for the entire period, my lord, he was not in service. So therefore, we had communicated, my lord, to the animal husbandry department.
Issue is 3/8/2009. He said, I want to come back and join. Wrote a letter saying, allow me to join now.
Absolutely. So that, of course, my lord, my colleague representing the veterinary department will have.
No answer. 2009 to 29/10/2012.
Absolutely.
This gap, only I want to know why, what happened? He's saying, I'm willing to come. Other side is saying, other side has not given any reasons.
Yes.
You are not giving a reason either.
My No, lord.
Who is the other side?
No, the other, if I may point out, on the other side, counsel was heard. This point was never, they couldn't answer because there was no whisper in the affidavit. I took a specific stand that I had to approach the court and judicial orders will allow him to join. Your lordship has rightly touched on that point. That point is silent and there the injustice is. I was willing to join. I'm a permanent employee and you don't allow me to join. In fact, from time to time, the director was saying that this post is vacant. We want this officer because he is our officer. It's a sanctioned post.
Yes.
So whether, why, for what reason, my lord, he was not allowed to join, that has to be traversed by the administrative department. He has already stated.
Have you taken up this matter with the administrative department also? When you pass
No, yes, definitely. There, our endorsement, which
all
my
that
lord
your
has,
passing orders are just this.
which lordship has right now seen, my lord, at page 20, the last page of our affidavit, my lord. Because we go by the inputs that are being given by the concerned administrative department. There, my lord, the administrative department concern is the animal husbandry department. Now, they have given the inputs, they have given the data. We have, my lord, scrutinized it and we have come to this conclusion. Because initially, my lord, the initial order, my lord, it is, my lord, 1/11/2005. Lordship may kindly come to, my lord, page 30 of the writ petition. That is the order. Of course, I am not representing the veterinary department, but this is the, my lord, order by which, my lord, he was allowed to go on deputation.
That part is, there's no dispute on that.
So day after, my lord.
Where is that?
Well, since they have not counted.
Where is Kakuti here?
Well, MM Katuti. Well,
Katuti or Kakuti? I can see.
Katuti, MM Katuti. Well, since they have not traversed in the doctrine of non-traverse comes in. So, and Lordship, this was not answered that day. I took up that plea. She had no answer because she could not have answered because there's nothing on her record on the affidavit. So this part is silent. My case is hinging on that you did not allow me to join when I was repeatedly. Why will I approach the High Court? I approached the High Court. In fact, the High Court, Honorable High Court passed an order that why are you not allowing? Pass a speaking order. It is only when I came here, by the time I lost 3 years, that I could join. And if I would not have gone to the High Court, they would not have allowed me. So that is my case. Your Lordship can close up because I have made my submission. Doctrine of non-traverse comes in. The Supreme Court is very clear. You're not traverse, you cannot. Even her making a submission at this stage won't help because she has not made anything in the affidavit, in her affidavit. Because I will be on fairly submitting, I will be relying on my affidavit.
Yes.
Because I do not represent the administrative department. And my lord, that administrative department has also, my lord, filed an affidavit in opposition.
Okay, I'll pass order.
My lord, I'm so obliged.
Yes, I heard. Mr. D. Heard.
I work with my lord.
DK Das, our brother for finance, and the other one was
MM Kotoki.
MM Kotoki. Kotoki or Kakuti?
Kotoki.
Kotoki.
Kotoki. She is the standing counsel for my lord, veterinary and animal husbandry department.
And DT Burman for
Referral number 4, Lordship.
response number
4. Personal department.
Obliged. Deeply obliged.
Item 23, admission.
May I please? This matter, my lord, my provincialization order has been cancelled, my lord, on the ground that my name was not appeared in the dice code, my lord, for the year 2006-7 to 2011-12, my lord. 2011-12, my lord. And my lord, on last occasion, my lord, the SSA was directed to obtain instruction whether, my lord, last order, my lord, order dated 7/2/2023, my lord. Whether the prior to 2019 there was were dice code or not, my lord. This was to be obtained, my lord, by the SSA, my lord.
Yes, anybody for SSA?
My lord, I am for elementary education department, my lord.
Also, my lord, elementary education has filed, no affidavit has been filed, my lord.
SSA.
Record we filed, my lord, affidavit, my lord.
Lordship, I'll get the instruction.
Yeah, Mr.
K. Uddin, my lord.
First, Standing council SSA. Is the matter again after 2 weeks?
3 weeks, Lordship.
My lord, the date may be fixed, my lord. Otherwise,
The matter again on 23rd March.
obliged.
My lord, item number 26, can it be fixed on 23rd of March, my lord? 23rd of March, item number 26.
Here for
I am for a respondent, my lord. You have informed the petitioner.
on request made by Mr. J. Parthawati to the council for respond number 3. The matter of 23rd March.
Lordship, item number 42 and 51, both the matter can be heard on 9th of March, my lord.
Oh, similar prayers regard item number 35 month.